Yes, good morning all, or good afternoon from my perspective. Are we ready to go?
Yes, Your Excellency.
Yes, okay, Mr. Trotter.
Your Excellency, when we left off yesterday, I just finished addressing the misleading evidence, I say, in Laken 2 and 3, giving the impression that Mrs. Gupta can't be trusted with a notification undertaking because she wasn't giving notice in relation to Villa K3. Now, I should deal with the 2 points that have been taken in response or defence to that. First, it was said yesterday that the 1st of May notice is really irrelevant because it came before the 21st of October when the variation application was issued. But Your Excellency, it's really beside the point. The timing doesn't matter. What matters is that Trafigura relied on the episode as if it showed Mrs. Gupta playing fast and loose with the notification regime in relation to the very same asset. And the judge should have been told that she did in fact give notice. The second point taken about this, perhaps one of more substance, is that Stevenson Harwood Dubai and Stevenson Harwood London are operating separately in separate jurisdictions. So it was said the 1st of May notice was sent to London. The urgent application was issued in Dubai. So how would Stevenson Harwood Dubai have known about a notice not sent to them? Your Excellency, that is a bad point, as we see from Mr. Laken's own evidence. If we look at C2 in the bundle, which is Mr. Laken's second witness statement, page 725, we see in the very first paragraph, Mr. Laken is the partner at Stevenson Harwood Dubai, and he has conduct of the matter together with a partner who's named there at Stevenson Harwood in London. And this same formulation appears in every one of the witness statements that is served. We also know that 3 of the 6 fee earners that were involved in the application were London-based. That's in Mr. Fedrigoli's witness statement at E3 1324. And we know that the reference is page 1324, paragraph 41.3b. And we know that from the statement of costs that was served on the last occasion. Mr. Fedrigoli identifies the 3 individuals who are London-based in his witness statement. And in the statement of costs, which is at C10837, I won't read them out, but the relevant fee earners are not A, B, and F. And we see in that statement of costs over at page 839 that one of those fee earners was amongst one of the 3 who were present at the 5th of November hearing. And we also see over at page 842 that all of those fee earners recorded time in relation to the preparation of the application on the 31st of October, which is the urgent application, and the hearing on the 5th of November, and in particular, preparing the witness statement of Mark Laken. Now, of course, that was only a 6-page witness statement. Anyone with any hand in preparing it could not possibly have missed the fact that a notice had been omitted, and it was suggesting that notice had not been given where in fact it had been. Now, we also know specifically that the 1st of May notice was sent to Stevenson Harwood Dubai because Mr. Wilm tells us that in his witness statement. That's at E4 1359. And I'll just read it out. It's at paragraph 110, which continues at the top of that page. Mr. Wilm states, in point of fact, I understand that Stevenson Harwood London sent the 1 May Villa K3 notice to Stevenson Harwood Dubai on the 20th of May, 2025. So there can be no doubt that first, the entire team is joined up and is working together on this application. and there can be no doubt that the 1st of May 2025 notice was specifically drawn to the attention of the Dubai team who were part of the team preparing this evidence. So this is a thoroughly bad excuse. The fact that it has been repeated in evidence and submissions really only serves to make clear that there is no good excuse for the misleading evidence that was placed before Justice Sir Jeremy Cook. So that's all I wish to say about the first Villa K1 notice. Now, the other two notices, the Platinum Tower notice and the second Villa K3 notice, are in a sense, and were in a sense, subsidiary points before Sir Jeremy Cook, because the point was not that Mrs. Gupta had just failed to give notice at all. The point was that the notice didn't contain the necessary particulars. Now, the point that we take in relation to these is that the breaches that are alleged are just totally untenable. Now, this point remains of substance today, because even now it's said that Mrs. Gupta was in breach of her obligations under the order. It's said that she was so in breach that she must have been acting dishonestly and in bad faith and cannot be trusted to comply with the notification injunction. Now, so far as concerns full and frank disclosure, Your Excellency fairly noted yesterday that the judge has the order, and insofar as it's a question of construction, then that's a point that the judge was perfectly capable of taking a view on. And I accept the force of that point, but I would say that this is not just a question of disclosure of things that the judge didn't have in front of him, but as we saw yesterday from Tugashev and Orlov, it's also a duty of fair presentation. The judge is grappling with a large amount of material at this hearing at very short notice, without the benefit of the reading time that one might usually have, faced with various allegations that are made loosely and not tied anywhere to the terms of the order that they're said to breach. There are also various other issues at the hearing that the judge had to deal with, so he was relying, as judges are entitled to do it without notice or short notice hearings, on counsel to present things fairly. Now, the details of all of this are set out in Mr. Fedrigoli's witness statement. I'm not going to go through all of them in detail, but I might perhaps just show Your Excellency the notices themselves.
I've just reread Mr. Fedrigoli's statement, and I noticed that the complaint is that they say that non-compliance was evidenced in respect of various particulars, which you say are not part of the requirement in any event, the notice requirement. Yes, and Your Excellency will have well in mind the established authority that freezing orders have to be construed strictly, because the breach of them is a serious matter. And so what's been going on here is that the Trafigura says, well, they want this and they want that. They want documents and they want valuations, and we should have told them about the counterparties and the dates and so on. None of that can be found in the order. None of it can be implied in, as though not providing it would amount to a contempt for a failure to do so. And fundamentally, we just say that was untenable. The point shouldn't have been run then. It shouldn't be run now. And that's really the thrust of this whole submission in relation to those two notices. Now, I should just deal with one specific point in relation to the second Villa K3 notice, because there's now a new allegation that the contents of that notice were dishonest. And I need to deal with that. One needs to see this in context. So can I start with the Platinum Tower notice, which is at K15 of the bundle, page 1242. Now we see it's an email from Hilal to Stevenson Harwood. It sets out the identity of the properties that are being sold, numbered there, and then immediately underneath, and this is important, the properties are being sold towards the settlement of an old trade debt of Vision Investments Limited incurred before the WFO and the Chabra order. That is the commercial purpose. And then underneath that, we have the estimated value and underneath that, the confirmation that Mrs. Gupta will comply with the restrictions on the use of the proceeds. Now, it's therefore been made clear that Vision is looking at selling properties in order to satisfy an old trade debt. Now, the next notice that's received, the second Villa K3 notice, is at K23. This is the one that's said to be dishonest. It's at page 2161 of the bundle. This is a letter from Larson to Stevenson Harwood on the 26th of October 2025. And again, we see it gives notice under Schedule C in relation to Villa 3. And then immediately under that, I am instructed that Villa 3 is being sold in order to realise funds for the operation and or maintenance of assets and in order to comply with clause 4.2, which requires Mrs. Gupta not to diminish the value of her shareholdings in Vision Investments Limited. Now, Trafigura can't, I accept that this perhaps could have been drafted slightly more clearly, but in its context, it's perfectly clear what's going on. The assets are being sold in order to maintain the value of Vision by ensuring that the creditors are paid. Now, the point that was taken specifically is not about this paragraph, it's 2 paragraphs down. Now, we need to read this quite carefully. It says, Mrs. Gupta further confirms that the proceeds will be applied in accordance with Clause 2 of Schedule C, including without limitation. And then the part that's criticised in particular is the end, the maintaining or operating excluded assets. Now, what's said is that the excluded assets refers only to the Vision properties, not to the shares in Vision. And that was false and must have been deliberately false because that wasn't the purpose. But Your Excellency, that is not a tenable reading of this letter. And if we look at the order to get a sense of what's going on here, that's at U58046. We're in Schedule C to the English Chabra order, and under paragraph 2 sets out the permitted uses of proceeds. And paragraph 2.3 in particular is the operating and or maintaining the assets listed in paragraph 3 above and the excluded assets. Now, paragraph 3 above includes the shares in Vision, which was one of the frozen assets. Now, what's happened, obviously, is there's some clumsy drafting in the Larson letter, where the words in paragraph 3 above and have been omitted, and instead the formulation has just repeated in substance paragraphs 2.1 and 2.3. But the letter makes perfectly clear in the specific paragraph that I read out a moment ago that the purpose of the sale was to maintain the value of the shares in Vision. And that was, moreover, a permitted use of the fees, of the proceeds, under the order. So it is just impossible to parse the words of this notice given by Mrs. Gupta's solicitors in London to suggest that this was somehow some dishonest statement in order to avoid the grip of the order. It's not a tenable allegation. So I say we can add that to the pile of completely unfair allegations of dishonesty made against Mrs. Gupta. So those are the notices. Finally, under this heading, there was an assertion about asset disclosure before Justice Sir Jeremy Cook. Now, as a result of the submissions that were made, the judge specifically records in his reasons, I don't think we need to turn it up, but the reference is D91279, paragraph 12. His Excellency says, as the claimants say, there is an apparent history of failure to disclose assets in the first place. And I highlight that because yesterday it was suggested that the point wasn't material, but it made its way into the court's judgment. And indeed, it was highly material because it was relied on to show that Mrs. Gupta cannot be trusted to comply with court orders. That's why it was in the evidence in the first place, and that's why it was in the judgment. Now, critically, Justice Sir Jeremy Cook was told that it was untrue that Mr. and Mrs. Gupta did not have a UAE bank account with more than $65,000. And the reason that he was told that was untrue was that Mr. and Mrs. Gupta had incurred legal fees in excess of that amount. And the references are all collected in paragraph 39 of Mr. Fedrigoli's first witness statement. But Your Excellency, the problem with that is that Trafigura knew that Mr. Gupta, at least, was receiving litigation funding. So it knew that the legal expenditure did not tell anything about whether there were undisclosed bank accounts and did not provide any basis at all for that inference. Now, to make that good, we see in J11 of the bundle, page 1834, this is the 12th witness statement of Ms. Grigoriades in England, dated the 25th of March 2025. And in paragraph 100 of that witness statement, there is a specific reference to the fact that D1 to D5, that includes Mr. Gupta, are in the process of entering into a new funding agreement with NOMAS. Ms. Grigoriades is the partner with joint conduct of the DIFC proceedings in general and the urgent application in particular, as we see from Lakin 3 and all the other witness statements. Mr. Lakin's firm was specifically aware, therefore, that NOMAS was funding the litigation. And there's another reference for that in Mr. Fedrigoli's witness statement, which is how they were told, paragraph 39.2, page 1323 of the bundle. And Mr. Lakin himself had set out in a detailed affidavit in these proceedings the details of Trafigura's knowledge of Mr. Gupta's litigation funding. That's at A3, page 28, an affidavit of the 11th of April, 2025. And at paragraph 110, there is a list of all of the different funders, of all of the different unnamed funders at that time that had been involved between 2024 and 2025. We also see this from submissions that were made recently on Trafigura's behalf in England. That's at C10, 1986, where at the consequentials hearing, leading counsel on behalf of Trafigura at page 17, lines 14 to 16, says, "We know and have known for some time, my lord, that an entity called NOMAS in the UAE was providing litigation funding to the defendants, and we were told that much at least." So everyone on the team is well aware, on the solicitor's team, is well aware that NOMAS is providing funding to Mr. Gupta. The obvious explanation for any discrepancy between Mrs. Gupta's funding and bank account disclosure was litigation funding of that kind. Now, none of this was mentioned to the judge. It was obviously material. It answered the very discrepancy on which Trafigura was relying. And again, I wish to make clear, I don't say that Mr. McPherson was aware of this. Indeed, it's clear that he cannot have been, because otherwise the point could not have been made in the skeleton argument in the way that it was. But Trafigura clearly was aware of it. So that's the second category of breach. The third concerns the nature of the order that was obtained and is perhaps the most serious so far as concerns its consequences. for Mrs. Gupta. The judge was told that the order he was making would cause no prejudice and hold the ring. The judge was not told that he was making an order that was or may be impossible to comply with. The judge was not told that Trafigura planned to enforce the order in the onshore courts, or that they would go about trying to arrest Mrs. Gupta on the basis of it. Before getting into the facts, there is some useful guidance on this in Grant and Mumford, the textbook I took Your Excellency to yesterday. It's in Authorities Bundle, tab 49, page 1412. And it's at the bottom of that page, in paragraph 26.068. And the learned authors say the material facts may also extend the intentions which the applicant has in relation to the ongoing litigation in which the application is made. There's a reference to, in Today Shaw, Matthews Limited and Marketing Ways Services, an issue arose as to whether the claimant should have disclosed its intention to seek a temporary restraining order in the United States. The claimant argued that the intention to apply for the American injunction was not material when the injunction had not removed the basis on which the English order had been made and was ancillary and supportive of the first order rather than being alternative to it. Mr. Justice Tier disagreed, saying that this adopted too narrow a view of materiality, which focused on whether or not the intention to seek the American injunction removed the basis for the claim for the English injunction. He stated, where a person applies for an ex parte injunction and intends to use the grant of that injunction to support an application for an injunction from another court in a foreign jurisdiction, such intention is a matter which reasonably could or should be taken into account by the judge in deciding whether to grant the application. That's because the intention affects or may affect the consequences of granting the injunction. Any judge of this court, when asked to grant an injunction ex parte, wishes to know the likely consequences of acceding to the application and making the requested order. If the judge is not informed of the applicant's intention to use the order in support of another application abroad, the judge will have an inadequate or incomplete appreciation of the likely consequences of making the requested order. In my judgment, the fact that the judge may still make the requested order having been told of the applicant's intention does not make the intention immaterial. The judge would expect to be told what the applicant intends to do with the injunction so that he or she can consider whether it remains appropriate to grant it. And that is in sharp focus in this case because, of course, that is the reason why the standard form freezing order in this jurisdiction, as in many others, contains the usual undertaking not to enforce the injunction outside the DIFC. And that's in the standard form in the annex to part 25 of the rules. And the reason that that is in the standard form here and in England is because of precisely this concern, because the court wants to know how its orders are going to be used. And if they are going to be used outside of the jurisdiction, then permission needs to be obtained and the basis for it explained. And the text then continues. We see a citation to Memory Corp in situ, a quote from Lord Justice Robert Walker, explaining that he sees some force that it's wrong to draw a distinction between the litigant's full disclosure of material facts and the summary of authorities and statutory provisions and practice directions. And then specifically at paragraph 27.70, there's a reference to a case called Memory Corp. And the issue in that case was that the order that had been presented departed from the usual standard form. And the Court of Appeal found, overturning the judge, that that amounted to a material non-disclosure, because it's not just about disclosing facts, it's also about disclosing other issues that may inform the court's willingness or otherwise to grant injunctive relief. So Standing back from all of that, there are really two aspects to this, one general and one specific, but both bound up together. The first is onshore enforcement and prejudice generally. Trafigura must have known what its plans were. Of course, I don't say that Mr. Macpherson was aware of that. Otherwise, I'm sure he would have explained why the usual undertaking was not included. And the second specific aspect is the impossible aspect of the order specifically. Now, on that, Trafigura now says, well, how could we have known? How could we have known that Mrs. Gupta didn't have the proceeds? But we've seen from the notices that Trafigura was told repeatedly that the property was being sold to repay creditors. We've seen that in the 1st of May notice, the 27th of August notice, and again in the Villa K3 notice. But if it was in any doubt, it was explained in crystal clear terms on the 3rd of November 2025, which is at K35 of the bundle, which is page 2181. This is a letter dated the 3rd of November 2025, again from Larson to Stevens Harwood, Middle East this time, the Dubai team. And it's the last paragraph that I'm interested in. The proposed sale of the villa is intended to generate liquidity required to meet Vision Investments' outstanding obligations to creditors and to ensure that Vision continues as a going concern. And then this, any attempt by your clients to obstruct that sale is commercially unjustifiable and risks precipitating Vision's insolvency. Now that email, that letter, is only sent a few days before the hearing, so Trafigura is well aware that once the villa is sold, the money will be reused to repay creditors, and it will be used for that purpose immediately, because there is a concern about Vision's ability to continue as a going concern. There is a concern about precipitating Vision's insolvency. Now, Trafigura's own evidence, when it obtained the interim order, was that it understood that Villa K3 could have been sold as early as the 31st of October 2025. That is 5 days before the hearing. I take that from Laken 4, D10 1282. This is the statement that was filed shortly after the hearing. At paragraphs 8 and 9, it stated that there was a check on the land registry on the 30th and the 31st of October, where Mrs. Gupta remained the owner, and the next check was on the 5th of November when she no longer was. So far as Trafigura were aware, when this order was obtained, the villa may have been sold as early as the 31st of October. Trafigura was therefore aware of the clear risk that the money would have been used to repay Vision's trade creditors at some point over the 5 days that had passed between the 31st of October and the hearing. The judge was not told of this risk. And as we'll see, Trafigura later uses the order in an attempt to put Mrs. Gupta in prison in Dubai for failing to comply with it. Now, there was a point...
That's all in Mr. Fredrigoli's statement, isn't it?
Yes, there may be some additional references in what I've given you just now, but the substance of it is there.
Yeah.
Now, there was a point taken yesterday that the order is not impossible because of the words any account in the name of. Now, so the suggestion was it only bites if the money is in fact in her account. But in my submission, that's far from clear. The order is mandatory and unqualified in its terms. It was going to be translated into Arabic, and we'll see that when it is enforced, that wording disappears from the order as described to the Dubai court. It should have been made much clearer, and the risk, if it had been highlighted, would have ensured that the order was not framed in the way that it was. Now, as to what happens after the hearing, we are told that the claimant applies the very next day, the 6th of November 2025, for conduit enforcement pursuant to RDC 45. The application is not exhibited to Mr. Lakin's witness statement and has never been provided to us, despite various requests. We pointed that out in our skeleton argument in February. That's at C9 826 46.1, paragraph 46.1 and 47. And even now, that document has not been provided. And now I say that is significant because, as I understand it, the P45 form, which one uses for the purposes of conduit enforcement, has a mandatory field for the quantum of the judgment debt. And as I understand it, that form just cannot be submitted with a 0. Something has to be inserted. Now, it may be that Stevenson Harwood entered 625 million in that field, and that may be why we later see HEDEF purporting to enforce a $625 million attachment against her, but we just don't know because we haven't got the document. An application then is made to enforce Sir Jeremy Cook's order in the onshore court. That happens on the 13th of November 2025. It's worth bringing that up because this is where the problems start to emerge. It's at L2 of the bundle, page 2317. And we see it's an execution petition. The relief that is sought is over the page 2318 in the blue box. It's the execution of the judgment rendered by the DOFC courts on the 5th of November. That's the interim order. And what's being asked for is a precautionary attachment against the funds of the respondents, it's Mr. and Mrs. Gupta, up to the amount of $625 million, which of course is not what the order provides at all. And we see over at page 2322, 14 in the table, Trafigura has attached what it describes as the adjudicated amount converted to AED. Of course, there is no such adjudicated amount at all. And then below that, the execution creditor authorises the court to take all necessary measures to execute that judgment forcibly. There is then an application against the Dubai Land Registry. We see that at L1 2314. This is an application on the 12th of November 2025, around the same time. And we see again in this that the Dubai court is very badly misled as to the nature of the interim order and its effects. If we go over the page to 2315, we see what the Dubai court is told. It said it has come to the attention that the execution applicants, that the judgment debtor, Mrs. Gupta, has disposed of the villa despite the existence of a court decision against her prohibiting her from disposing of funds belonging to her in the limits of 2.2 billion dirham. Now, of course, there is no such order against Mrs. Gupta, and there never has been. And in any event, Villa K3 was disposed of and the property transfer occurred before the interim order was made. So that is wrong. We then see at L5 2335 of the bundle, the Dubai Land Department produces the contract in response to the application made against it. So it produces the sale contract for Villa K3. And that contract is in the bundle at M40 2719. I need to address this because it was suggested yesterday that Your Excellency should again find that Mrs. Gupta is giving dishonest evidence that the payment was made directly to Sharp Trend, and it was said that that is contrary to the terms of the contract. And that is wrong. if we look at page 2725 of the bundle, we see the additional conditions under a bold heading at the bottom of that page. Clause 1 explains the deposit. Your Excellency was told yesterday, well, it's just not right that all the money was paid directly to Sharp Trend because there was a deposit paid to Mrs. Gupta. We see from this clause, the buyer shall pay a 10% non-cash security deposit in the name of the seller, that's Mrs. Gupta. The buyer's deposit check shall then be held by the deposit holder, and on the date of the transfer, the 10% security check will be exchanged for the 100% selling price in the form of the manager's check. So the deposit at completion is sent back, and in its place will be provided the entire sale price in manager's checks. Clause 2, the capitalised heading, payment to the seller's authorised representative. The buyer acknowledges and agrees the payment of the sale price to the seller may be made in the name of an appointed attorney or representative by the seller. So Mrs. Gupta can appoint and direct that the sale price be paid to a party appointed by her. Now, this is all entirely consistent with Mrs. Gupta's evidence and the documentary record, to which I'll come, that the sale price was paid in full and directly to Sharp Trend by Arnoux. So this is a bad point. There is express provision in the contract which shows that. Trafigura should have been aware of it at the time, and it certainly should have been aware of it now. Now, a month later, despite having all of this, there is an application to enforce the impossible order. And that is at L9 2377 of the bundle. We see the date of the online application is December 17, 2025. And then at the bottom of the page, the contents of Sir Jeremy Cook's order are quoted, but without the critical part on which my learned friend now relies. The text of clause 5 stipulates that in the case of a villa sale, the judgment debtor should not dispose of the sale proceeds and must, within 24 hours from the date of issuing the order, transfer the villa sale proceeds to the treasury of the Dubai International Financial Centre's courts. The words any bank account are gone. So if it was not an absolute obligation before, then it certainly is presented as one now. And we see below that the relief being sought is on penalty of arrest and summon. It's just above the numbered paragraphs. And paragraph 3, to oblige her to transfer the sale proceeds to the Dubai court's treasury. Now, if Trafigura was in any doubt as to what had gone on and the risk that the monies had been paid to Vision's creditors, then this was made crystal clear by Mrs. Gupta's second witness statement, which was served on the 5th of January 2026. That's at C5762. And I'll just read it out. It's paragraphs 20 and 21. The proceeds from the sale of Villa K3 have been utilised to set off certain liabilities incurred by Vision prior to the DIFC freezing order. I pause to note that that's exactly what Trafigura have been told several times in correspondence. And then paragraph 21, the proceeds of sale of 22.25 million is paid directly to a debt recovery agency appointed by creditors of Vision. So Trafigura are now well aware, beyond any doubt, that the monies are not and have never been in Mrs. Gupta's possession. Now, despite all of this, on the 11th of February 2026, which is a month later, an arrest warrant is requested from the Dubai courts. That is at L13 2404. The 11th of February, so this is before the return date, before the Chief Justice. and it's before Onima come on the record for Mrs. Gupta. So Mrs. Gupta is unrepresented, and she has not had a chance to come back before the court in relation to this issue. And we see the request relates again to the 5th of November order, imposing, it says, precautionary attachment on the funds of the judgment debtors, as Mrs. Gupta has described, within the limits of an amount of $625 million US. So there is a gross misdescription of the order once again. Then over the page, on page 2405, second paragraph down describing the text of clause 5, once again, the judgment debtor must, within 24 hours from the issuing of the date of the order, transfer the villa sale proceeds to the treasury of the DIFC courts. Again, the reference to any account is gone. And below that, there is a request to the judgment debtor was duly notified of the writ, obliging her to deposit in the amount of the treasury in accordance with the text of the writ. And accordingly,
does that term judgment debtor have some more expanded meaning onshore than what one normally understands the term judgment debtor to mean?
Well, Your Excellency, one often sees in all the translated documents references to respondent.
Yes.
So if it meant respondent, it would say respondent. What we do see from Mrs. Gupta's evidence is that her account has inexplicably been driven into a massive negative balance. And it may be that the difference between judgment, the specific wording of judgment debtor doesn't really matter. What matters is that the orders being presented as though it were a precautionary attachment, at least, on her assets of $625 million.
But doesn't the term judgment debtor mean somebody who's got a money judgment against them?
Well, that's an additional problem. I agree.
It's a fairly core problem, isn't
it? It's extremely grave, and that's why.
I mean, she has a kind of Chabra order against her, a freezing order, but that doesn't turn you into a judgment debtor.
Well, no, precisely. And indeed, there's really two problems here. First of all, even the Chabra order is being misdescribed because, of course, that only applies to specific assets. There's not and has never been a claim against Mrs. Gupta for $625 million, much less a precautionary attachment for a maximum sum of that amount. Indeed, that's precisely what His Honour Judge Pelling refused to make back in 2023. But as Your Excellency points out, it's worse than that, because she's being described as a judgment debtor who actually owes this money, which is just plainly wrong. And so what emerges from all of this is that the claimants are seeking to arrest Mrs. Gupta, put her in prison in onshore Dubai. They are misrepresenting the nature of the order very badly. And all of this is before coming back before the Chief Justice. And all of it is despite telling Sir Jeremy Cook that there would be no prejudice from the order, and despite the fact that it was not mentioned that the usual undertaking not to do so had been omitted. Now, it is only fortunate that the Dubai court refused this request and required that Mrs. Gupta be given notice before it continued to issue it. But Trafigura's intention was, of course, to carry on down that path, and it's only because the Chief Justice made an order at the February hearing requiring it to cease enforcement action onshore that Mrs. Gupta is not presently in prison in Dubai. Now, Mrs. Gupta explains the effect that this has had on her. I think it's important that I take Your Excellency to her witness statement on this. You may have read it already, and so if so, it may not be necessary to turn it up.
I'm just looking at the accumulation of complaints about Trafigura's conduct, mainly in relation to the proceedings before Sir Jeremy. But ultimately, I think looking at 199 of your skeleton, you bring this to bear on the discretion of the court. Isn't that right?
Yeah, so I mean, it's relevant, I think, to three things, Your Excellency. First of all, it's relevant in the various ways I've described to full and frank disclosure, because these are all things that should have been mentioned at the time and weren't, and were justified.
What does that lead to? It leads to
Yes.
a factor relevant to the exercise of the court's discretion, which is being sought by the claimant in the variation of the order.
Yes, so if Your Excellency is minded to discharge the order on the basis of these breaches, then there is a question whether to re-grant the order, and if so, on what terms. And there's, in effect, a narrow window through which the claimants can pass, if they satisfy Your Excellency, that the merits of the case are such that there really ought to be an injunction in any case. So it does affect the discretion.
That's why I'm wondering whether there's a sense in which these matters are, one sense in which they're academic. I mean, the best case outcome from your point of view would be, well, this was such an egregious accumulation of these misconduct that the injunction as granted ought to be discharged, but that doesn't deal with the question whether the injunction now as sought ought to be granted. And then the conduct falls into the area of discretion to grant or withhold. And because we're having a big argument about the application of Chabra principles, the merits are in full play in these proceedings.
Excellency, yes, there's some useful guidance again on this in Tugashev. Perhaps we should turn that up, or I can just read it out.
You just give me your answer.
The answer is that I'll just put it in the words of Mr. Justice Carr rather than my own. The court has a discretion to continue the injunction or impose a fresh injunction despite a breach of the duty. Yeah. That discretion, Mr. Justice Carr says, should be exercised sparingly. Considerations include the importance of the facts not disclosed, the need to encourage proper compliance with the duty, whether or not the failure was culpable, and the injustice to the claimant, which may occur if an order is not granted. Although it's made express, a strong case on the merits will never be a good excuse for a failure to disclose material facts. So we say that the path is narrow.
I understand that a strong case on the merits is not an excuse for a failure to disclose material facts. But the question is, does it act as does the failure to disclose material facts act as a bar to the grant of relief? I don't think you put your case that high. You seem in the skeleton to say it's a discretionary factor.
I can't put it that high, Your Excellency. In the end, it is a matter of discretion. But I do say that these breaches, they're serious in nature and serious in their consequences. There's not even a contingent apology for them. There's no attempt to remedy the consequences that have occurred before the onshore courts. And I do invite Your Excellency to mark the court's disapproval of them by discharging the interim order and by declining to grant further relief.
But then there'd be a halfway house in the sense that you might say, well, if you're not prepared to discharge, you shouldn't be prepared to give them a more draconian order than they presently have.
Yes, Your Excellency, I do adopt that alternative position. And an additional layer on top of all of this, which I'll come to at the very end, is in relation to onshore enforcement, there's a question of the court's supervision of Trafigura's enforcement processes. And there's authority to the effect that the court, when granting an injunction, especially if it's going to be used offshore, even if that's appropriate, then it ought to be subject to the court's supervision and granted on terms. And so I will say that if Your Excellency is minded to grant an injunction of any kind at all, and if Your Excellency is minded to grant permission for that to be enforced outside the DIFC, then effectively Trafigura ought to do what they say they are going to do by pursuing these particular UAE law routes, and they ought to do so in short order. I'll come on to all of that when we get there. I need to work through the UAE law issues.
Yes, okay. But I just wanted to get a sense of we can go blow by blow, if you like, through the alleged failures to disclose and the associated conduct, but the ultimate outcome goes to discretion with a range of possible results.
That's right, Your Excellency. Although the authorities do make clear that where there's been a serious breach of full and frank disclosure, then the ordinary course is to discharge without a re-grant of relief, unless the claimants can persuade Your Excellency that it's nevertheless appropriate to re-grant that relief in this case.
Well, if I was satisfied that there'd been a breach, at the same time I was satisfied that there was on the merits support for Cabra relief against Mrs. Gupta, then it becomes a matter of balancing considerations which might be in tension.
Yes, I accept that.
All right.
Perhaps I should then move on to the variation application and deal with some of those merits issues. Now, I want to deal with the variation application as it's been termed in 4 parts. First, the UAE law enforcement routes, which are taken very lightly by my learned friends, and I say are fundamentally not open. Second, the evidence and why Trafigura can't bring itself within those pathways in any event. Third, the justice or convenience question, which effectively turns on, as my learned friend said, the prejudice and the alleged risk. And fourth, I'll deal with that question of onshore enforcement in the event that any injunctive relief is granted. Before I embark on that...
That could be covered, of course, by a requirement of prior notice to the DIFC court.
Well, Your Excellency, I'll come on to the detail, but a prelude. On the onshore enforcement issue, there's really 2 questions. First, whether the statutory scheme even allows the enforcement of interim relief through the conduit jurisdiction, which I say it plainly doesn't. Mm-hmm. And second, if it does, then the Dardorian factors about whether and on what terms permission should be granted to enforce the injunction in the onshore courts or indeed anywhere in the world. Now, before I come on to the merits, Your Excellency asked Mr. Peters yesterday if the intrusiveness of the order sought might impact on the strength of the case that my learned friend needs to show. And Mr. Peters' answer to that, I think, was no. My answer to it is yes.
So my answer was a qualified yes.
I see. Well, I'll give my answer, and Mr. Peters can say in reply whether he agrees or not. But there is some authority in this court on that topic.
The question I thought I put, Mr. Trotter, was whether the strength of the case, whether what I had to balance out, and this is traditional interim injunctive relief in Australia, of course, is the strength of the case versus the prejudice to the parties, if it's granted or not granted, as the case may be.
Yes, that's perhaps what I meant to say if I put it badly.
Yeah.
But in short, Your Excellency is right about that. And of course, Your Excellency has given the leading judgment on that question in this court as well. And that has been recently adopted by Justice Moran in a case that is in the bundle. And perhaps I should just take Your Excellency to that. It's at tab 5 of the authorities bundle, page 139. Now, this is a case where the claimant, Mr. Abramenko, sought an injunction against the defendant, Mr. Chupran, to restrain him from causing a group of gaming companies to deal with their assets. And the claimant alleged that the companies were held on trust. That was denied by the defendant. The claimant sought an interim injunction pending the resolution of that dispute. The facts are summarised over on page 141 of the bundle from paragraphs 2 to 7. Won't go through all of that in detail. What matters for our purposes is the nature of the relief that was sought, which we see over at paragraph 9 on the next page. There's a quote, helpfully, from the draft order just below the indented paragraph 3. And the relief being sought is that the defendant not make changes to the governance structure or operation of the companies, including but not limited to financial transactions, transfer of assets, decision-making authority, or interfere with the administration, financial management, or day-to-day operations. So the relief that's being sought is effectively to lock the companies up and make sure that they're not dealing with any assets or indeed doing anything at all pending resolution of the disputes, or at least not by the defendant. Now, the relevant passage starts over the page over 2 pages at 144. At paragraph 27, there's a discussion of Your Excellency's decision in LXT Real Estate Broker. And we see at paragraph 28, Your Excellency is there referring to Beecham Group, the High Court decision, explaining that the claimant, the plaintiff, is to make out a prima facie case in the sense that if the evidence remains as it is, there's a probability at the trial that of the action that the plaintiff will be entitled to relief. And the requisite strength of that probability depends on the practical consequences likely to flow from the order. We see at 29 through to 31, that matter was revisited and affirmed in ABC and O'Neill in Australia. Then over at paragraph 33, having discussed the approach further, His Excellency Justice Moran explains that there are cases where the more demanding Australian approach will apply as a more suitable means. And the approach is then applied after a lengthy discussion of the facts over at page 148, at paragraphs 50 through to 55 at the bottom of that page. And particularly at paragraph 53, the American cyanamide approach is not, however, in my view, the optimal approach in the particular circumstances of this case. In my judgment, selection of a fair interim remedy requires a more rigorous estimation of the prospects of success, not just oath against oath. It's fair and appropriate for me in the exercise of my discretion to be guided by the Australian victim in relation to the requisite strength of probability. Now, ultimately, the judge refuses the more coercive relief that's sought, and instead undertakings are often offered and said to have been rightly offered, and those undertakings are over at page 152 of the bundle. And we see that they're in a much more conventional form, and they are not to transfer or otherwise dissipate or intentionally diminish the value of the shareholding, not to take any dividends from the company, and not to cause the companies to enter a transaction other than in the ordinary course of business. And of course, that is the conventional form, because the interest of the claimant in this case, as it was in that case, is to enforce against the shares, not in relation to the underlying assets of the companies. And so the claimant's interest is in preventing dissipation of the value of those shares, not in preventing the company from doing anything at all. And we are really squarely in that territory in this case, because the order being sought by my learned friend seeks to freeze up all of Vision's assets and prevent it from dealing with them in any way. In fact, it goes further than that. Perhaps we should just turn it up so we see what my friend is asking for. It's at page 32 of his skeleton argument. Paragraph 65. What's sought is absolute injunctions in relation to Villa K1, 65.1, 65.2, all of Vision's assets, the reference to real property, the liquid stake in Silver Star, and then 65.3, D2's Vision in shareholding. Now, Your Excellency, I should say this goes rather beyond what the application notice asks for, which is just orders in respect of the Vision properties. So I do object to new relief being sought without an application. But whether it's in respect of everyone's assets or just the Vision properties, the effect of the relief sought is to lock up those assets absolutely. There is no provision in the order sought for the ordinary and proper course of business. There is no provision for the repayment of creditors, as Vision is, as we've seen from the evidence, trying to do to maintain its value. There is no exception in the order proposed in my letter friend's skeleton argument for living expenses or legal fees, standard exceptions in the freezing order, even though he is seeking a full-blown freezing order over all of Mrs. Gupta's assets. Your Excellency has not even been addressed on any of the authorities about why those exceptions are essential. I'm not aware of any case in which a complete freezing
Sorry, just to
of
be clear, I think there may be a misapprehension, which is why I'm interrupting. The assets of Mrs. Gupta's in relation to which we are seeking an unqualified order are Villa K1 and the shares in Vision, not everything.
Well, those are all of the assets. If we look at Mrs. Gupta's asset disclosure, which will tell us what Mrs. Gupta's assets are.
I hesitate to interrupt. Mr. Hume, can you please ensure that your camera is turned off? Thank you.
Yes, go on, Mr. Troy.
Mrs. Gupta's asset disclosure explains what her assets are as at May 2025 when she gave it. That's it. We don't need to turn it up. It's a B1/438. And they were, of course, Villa K3, which has been sold, and the money repaid to Sharp Trend, Villa K1, and the Vision shares. And in her witness statement, she's explained she has a car that is worth less than $65,000. But outside of that, the order that's being sought is seeking to freeze substantially all of Mrs. Gupta's assets, and certainly all of those valued at $65,000 or more. And I do say that that is a highly unconventional order without any provision for living expenses and so on. It's not been justified at all. But in any case, the point that I'm making at the moment is that in relation to Vision, it is of exactly the kind of order functioning the same as what was being sought and refused in Abramenko, which would require the higher standard identified in that case. Now, with that, can I turn to the first heading under the variation application, which is the execution routes. Can I start with what I believe to be common ground? 4 points. First, it's common ground that the guiding principle of the Chabra injunction, like any other freezing order, is to further the enforcement principle. Second, it's common ground that Trafigura must therefore show a reason to believe that the assets would be amenable through some process of execution. Or if I'm right about what I've addressed Your Excellency on a moment ago, a higher probability than just reason to believe. Third, it's common ground that it's not necessary, of course, for Trafigura to show that the assets are beneficially owned by the Chabra defendant. But fourth, and conversely, it's not sufficient to show that the defendant has some control over the assets in some broader sense. So it's not sufficient that Mr. Gupta could, by asking Mrs. Gupta nicely, cause assets to be applied to Trafigura's judgment debt, if that is the case. Now, so far as concerns the routes available under UAE law, there are, I think, 2 points which are equally uncontroversial. First, the code provides routes for creditors and in particular 3 conventional routes to protect against debtors disposing of their assets. And second, there is not, on the other hand, a concept of separate beneficial ownership in the way that there is in the common law world. And so what one cannot do is go and get a charging order over property on the basis that it is held on trust. And certainly no one is claiming that a waqf applies in this case. Now, as to those routes that are available, there is a useful summary of them in the explanatory memorandum to the Civil Code, which Stevenson Harwood have helpfully provided. That's at R6 of the bundle, page 5087. And this document is what's sometimes called the Ministry of Justice commentary, sometimes called the explanatory memorandum to the code, but it's effectively the authoritative government commentary on the Civil Code, which has been translated in this document. And we see at the top of page 5087, the 3 actions are being described. They're the indirect action, the Paulian action, and the action in simulation. And they each protect the creditor in different ways. So for the indirect action, the creditor safeguards himself against the consequences of the debtor's negligence or fraud, where the debtor fails to claim his rights against third parties. So that's a sort of subrogation action or surrogate action where the creditor can exercise the debtor's own rights. Second, the Paulian action, creditor protects himself against the consequences of the debtor's fraud, where the debtor disposes of his assets to the prejudice of the creditor's rights. So that's a sort of equivalent to Section 423 of the Insolvency Act in the UK, or I've given the New South Wales and Western Australian equivalents in my skeleton name, which to my shame I now can't remember. They're effectively clawing back assets that have been transferred away to third parties. And then third, an action in simulation, where the debtor purports to dispose of his assets in order to remove them from the general guarantee, the general body of his assets available to creditors, through a simulated transaction. And that's all about sham contracts. Now, what we see from the scheme, and these are all contained in the same chapter of the code, is that my learned friend is quite right, of course, to say that UAE law provides protections for creditors, as one would expect from a sophisticated legal system. It's not a fraudster's charter, but the way in which it does so is by largely unwinding transactions or by allowing a creditor to stand in the debtor's shoes. Now, in some respects, these mechanisms are a great deal more powerful than would be available in common law jurisdictions. The indirect action is a standout, and also the Paulian action is a very good example. If we see what's said about that in particular in the same Ministry of Justice commentary, but a different translation at R18 of the bundle. I'm not saying there's anything different about the translations, just that the different sections have been produced in different clips. This is the James Whelan translation of the Ministry of Justice commentary we were just looking at. We see Articles 396 and 397. This is the Paulian action. And basically how the scheme of these work is that under 396, if obligations, due or deferred, exceed the assets of the obligor, then he can't make any voluntary disposition. So if you owe money that is more than your assets, you can't give away property. And then under 397, if a claim is brought against you and the claim is for an amount exceeding your assets, then one's not allowed to make any voluntary disposition or even dispose by way of a commutative contract notwithstanding the absence of preference. And so the effect of that is, once a claim is brought against a person, if the claim exceeds the value of their assets, then they're prohibited from disposing of assets even for value. Now, that's a very powerful protection for creditors. Over the page, the consequences are described in the commentary helpfully below, which describes this Article 397 as dealing with what's called a general bankruptcy. And at the bottom, the creditors can come between him and his assets and prevent him from making any sale or transaction just by bringing a claim. And over the page, we see 5 lines down, a general bankruptcy is similar to a special bankruptcy. And 2 paragraphs down from that, with regard to the effects flowing from a general bankruptcy, are very similar to those flowing from a special bankruptcy. They are considerably more severe than the mere fact that the debt exceeds the assets of the debtor. That's Article 396, but without the creditors bringing an action against him. In the case of a general bankruptcy, it's not permissible for the debtor even to make a gift of his goods, nor may he make a commutative disposition of them, even without preference, nor may he make payment of a deferred debt that's not yet due for payment, and so on. So this is an extremely powerful protection. It makes Section 423 of the Insolvency Act look like a water pistol. It prevents any dispositions at all in these circumstances. Now, the problem is that my learned friend needs to bring himself within one of these routes. It's not enough to just say, as he did yesterday and as he does in his skeleton, oh, well, Mrs. Gupta is holding assets or controlling them as a nominee. It's a good arguable basis that the assets can be treated as assets of D1. It's paragraphs 17.2 and 17.3 of his skeleton. This is loose terminology. It is not enough. Now, insofar as my learned friend does identify UAE law routes, what is quite notable is that Trafigura's position has travelled some distance from its expert evidence, because the case that was developed over 2 rounds of expert evidence from Stevenson Harwood Dubai and then M&Co were focused very much on routes to enforce the judgment against the properties themselves. And Your Excellency will have seen that I dealt with all of those in my skeleton argument. There's various problems with them, and they are now all gone. Instead, the new route on which my learned friend relies is all about focused on recovering the shares in Vision. There's no longer any question about unwinding the transfers of the properties from P Prime to Vision, collapsing the corporate personality of P Prime in order to vest those rights in Mr. Gupta, or any of those analyses. Instead, the suggestion is that the shares in Vision can just be reconstituted as shares owned by Mr. Gupta. But Your Excellency, this new case has all sorts of problems with it as well, because it is really just an attempt to imprint the common law concept of a trust into the UAE law framework. Now, it's put in 2 ways. Can I start with the action in simulation? This is where it's said that the articles of association of Vision are a sham, and that in fact the hidden contract is that Mrs. Gupta is the shareholder of this company. And can I start with the provisions of the code? They're in this same tab that we're in now, but at page 5296.
Yes.
And so Article 394, we see if a sham contract is made, the obligees of the contracting parties and special successors may rely on the sham contract and also on the hidden contract, may prove by all means the nature of the sham contract by which they're prejudiced. 2, if there's a conflict of interest, that case doesn't concern us. And then 395 is about the contracting parties themselves. And so what Trafigura needs to rely on is Article 394(1 as the obligee of a contracting party, relying, it says, on the hidden contract. Now, the premise for this concept of sham contracts is a contractual one. It's based on intention. And we see that below in the commentary at 2.0588. If a contract is a sham, that alone is not enough for it to be void. The basic rule is that regard shall be had to the hidden contract to the exclusion of the apparent contract, as this would be consistent with the intention of the parties. That's all very unsurprising. The question is, was there a hidden contract and a sham contract at the time that it was created?
Does this pick up a what we call an arrangement or understanding, which has the hidden transaction that doesn't involve an intention to have legally binding relations, as the term contract normally conveys?
Well, Your Excellency, there's no sign of any such concept in the authorities. What we see repeated throughout.
We're the translation of the article, aren't we?
Yes, we are, Your Excellency. There's two translations, but I don't think anything material turns on the difference. But there's quite a useful encapsulation of the principle in a judgment of the Federal Supreme Court, 476 of 2011. That's at R23 of the bundle, page 5338.
Yeah.
And if we go over to page 5339, just read it out. It's in the middle of the large paragraph on that page, about 10 lines down or so. It says it's established that the simulation in law is the establishment of voluntary legal appearance in a matter contrary to reality to give the illusion of validity, conceal the true intention of the parties. It creates two distinct situations, a hidden true situation and an apparent false one. The latter is the simulated situation, either concluding a simulated contract or by unilateral disposition. So it applies to gifts as well as contracts. It's based, and this is the critical part really, it's based on a dual agreement, as the parties agree to adopt two courses of action, concealing that they agree to execute between themselves and giving the illusion of the enforceability of the simulated situation. And the experts each give quite similar formulations to that in their respective letters. But what I draw from this is that there are three things really. First, it's necessary to identify an apparent contract and a hidden contract, as the terms of the code and the formulations in the cases make clear that it's a corrective mechanism, not a substitutive one. And so what one does not see in any of the cases is simply substituting one party for another, saying that a company is owned by one person. In fact, it's owned by someone completely different, because that is not correcting a sham contract. On my learned friend's case, there is in fact no contract between Mr. and Mrs. Gupta at all, nor is there a hidden contract between them. What he's saying is that the hidden contract is just an entirely new company with an entirely different shareholder. Second, the question is whether the contract was a sham at the time that it was formed. And of course, this may not be controversial because it's entirely consistent with English law that a contract that is genuine when made does not become a snook sham because the party's intentions change. And a simulated contract can't conceal a hidden one if the true agreement doesn't exist at the time the simulation is executed. And I'll come on to this, but that's significant because Vision was incorporated in 2016, long before any wrongdoing is alleged, and long before Mr. Gupta was even doing business with Trafigura in any way. The third point about simulated contracts is the evidential control which the UAE courts impose on this mechanism. And that is that the hidden contract must, save for a limited exception, be proved in writing. So if you want to show that there was a hidden contract, you have to produce that hidden contract in order to rely on it. Now, the existence of that evidentiary principle is common ground. The exception to it is disputed. We can see what Trafigura's expert evidence says about this at R4 of the bundle, at 4907. This is the M & Co letter, second round of expert evidence from Trafigura. At paragraph 4.15, M & Co accept that the rule as applied by both the Federal Supreme Court and the Dubai Court of Cassation exists, but there is a dispute about the exception that applies. And the exception is quoted in the two paragraphs below. Now, M & Co's position is that it applies to any third party. So this evidentiary requirement just doesn't apply if you're a non-party to the contract. And it's said at the end of paragraph 4.15 that that exception is well recognized. But Your Excellency, when we read the passages that are quoted, they just do not support that proposition at all. So under paragraph A, the proof of the simulation of the contract subject to the general rules, where the contract is in writing, the general rule is that the simulation must be established in writing. But where there is fraud or circumvention of the law, it is permissible for the party against whose interest such conduct is directed to prove the simulation in other ways. So there must be fraud or circumvention of the law, and that conduct has to be directed at the party who is alleging simulation. This is an evidentiary control against any third party just coming along and undermining the stability of apparent contractual dealings. We see the same thing from the UAE Federal Supreme Court over the page in almost the same terms. So it's established as a reference to the law of evidence, where a contract is evidenced in writing, neither party thereto may prove its simulation, whether against another contracting party or a third party, except in accordance with the general rules. It's the same general principle. And then the exception is described in the same terms. Where there's a fraud or circumvention of the law, the party against whose interest is directed may prove the simulation of the contract by all permissible means of proof. Now, it was said yesterday that there must have been fraud or circumvention of the law. Well, it was just asserted. There was no basis for that, no law identified that had been circumvented, no fraud identified in the incorporation of Vision in 2016. But in any event, it's chronologically illiterate to say that the fraud or circumvention is directed at Trafigura. The contract, which is said to be simulated, we can see at P233987, which is the Memorandum of Association of GG Property Holdings Limited, as it then was. The last page of that over at 3991, the amount of shares, all of the shares are issued to Mrs. Gupta. And this is the document that dates from 2016. Now, Trafigura will need to go before a Dubai court and will need to tell that court that this document is simulated and that, in fact, the true agreement was that Mr. Gupta was the shareholder of this company. Now, I've said that there's no authority anywhere that suggests that you can engage in that sort of substitution. But in any case, Trafigura are going to have to show that this was a fraud targeted at them. It's years before Mr. Gupta even does business with them. Now, my learned friend's answer to this was to say, well, there's some Egyptian cases. The Egyptian cases give a different view. Now, that is true. The Egyptian cases do give a different view. He said my position is just that the UAE law courts might not follow them. That's not what I say. The point is that the UAE courts consistently adopt a different principle at the highest level. And at page 32 of my skeleton argument, paragraph 110, there are references to 4 Dubai Court of Cassation cases and an Abu Dhabi Court of Cassation case, which all state the same principle. So it's not just that the Dubai courts might not follow it, it's that it's utterly hopeless. Trafigura would have to take this to the apex appellate court and invite it to depart from well-established authority. It would be a bit like walking into a court in London and trying to rely on Walton Stores and Mar. They just look at you like you've got 2 heads. It will not work. I say out of bitter experience.
Well, there are often differences between respectable common law jurisdictions.
Of course, and the same might be said, or at least might have been said until recently, about the law of unjust enrichment going back the other way.
Yeah, if you look up the term radical departure from existing principle, you'll see it's been used by apex courts in both the UK and Australia about each other. You can Google it, I think. Anyway, go on. Sorry, we're getting off point here.
So the point is that this is just totally hopeless. Now, my learned friend relies on 2 cases where he says the articles of association were held to be simulations. That is true, but they are consistent with the scheme that I've just described. Perhaps we should just turn one of them up. It's at R75091. This is a decision of the Dubai Court of Cassation, number 1736 of 2025. And broadly, we see the facts in the first paragraph, but what's going on is that the company is formed with 2 shareholders, and there's a local shareholder that's been included just to meet the 51% local ownership requirement that was in place at the relevant time. And we see at the end of the first paragraph, about 5 lines up from the bottom, the appellant had at the time signed an acknowledgement stating that he did not pay his share capital, which is fully paid up by the first respondent, and that it's wholly owned with all of its movable and immovable assets by the first respondent. So there's a written acknowledgement by the nominee shareholder that they're not the real shareholder. And in fact, that question is not even in dispute in this case. The dispute instead concerns whether that hidden agreement is void for breach of public order because it was illegal at the time it was made. As the context is that there's then a subsequent law that removes this requirement, as we see the next paragraph down, Federal Law 2 of 2015, no longer requires citizens to own 51% of local companies. The argument is then stated and the reasons for rejecting it are given. If we go over to 5094, and it's the paragraph in the middle of the page. The court holds that contracts cannot be invalidated on the basis that they constitute sham arrangements or due to participation one or more of UAE nationals holding 51% of the capital, even if those contracts were concluded prior to the issuance, it's a reference to the new law, provided that no final and conclusive judgment invalidating them was issued before its entry into force. And so the conclusion that the court is reaching is that even though this sham arrangement was entered into prior to the new law at a time when it was illegal, it's still open to rely upon it. Now, there's another useful encapsulation of the general principle at the bottom of that page. According to the jurisprudence of this court, the contracting parties, the reference to Article 395, hired a genuine contract, had a sham contract. In effect, the contract in effect between the parties is the real genuine one. And over the page, we see the evidential principle is stated again. Now, there seem to be a run of these cases because the other judgment on which my learned friend relies is on basically the same facts, but it's not actually, it's not based on any facts at all. It's an advisory judgment that the court has been asked to issue in order to resolve a conflict that's emerged between different courts about this question of public policy and about whether a company entered into a company created before the new law can nevertheless be rectified, or whether that's void because it was illegal at the time, and the court holds reaches the same conclusion as in this case, that it's not void for public policy. That we don't need to turn it up, but that case at R22/5335. So all of this is entirely consistent with the scheme that I've described. First, this is not an instance of one shareholder, a sole shareholder company, just being suddenly put in someone else's name entirely. It's a contract between two people that was found to be a sham. Second, it's a hidden contract and a apparent contract at the time that the company is created. And third, there's a clear no problem with the evidential basis because there's a written acknowledgement, and indeed it's not even in dispute that it was a sham. So those cases really don't take Trafigura any further at all. So that's simulated contract. The next basis on which it is put is the indirect action. And it said, my learned friend's skeleton argument, paragraph 42.2, says, if it were to be established that D2 is holding assets as a nominee for D1, these rights would encompass D1's rights to demand that the assets be delivered up to him.
Sorry, I apologise. I'm doing my HR bit again. I think the transcribers need a break. And
that might be a convenient time.
Yeah, sorry.
Thank you, Mr. Peters. You'll get a gold star for that. All right, we'll take a break for 15 minutes and come back at 1:45 whatever it is everywhere. Thank you. Okay, we're all ready to go. Yes, Mr. Trotter.
Thank you, Your Excellency. Your screen appears to have gone black, so we can't see you, I'm afraid.
I'm frozen. Just a minute, I'll try again. It just sent up a message saying try another device, which is a bit disturbing. Here we are. All right.
Thank you, Excellency. I was moving on then to address the second route, which has been proposed. It said that there could be an indirect action on the basis that it could be established, my learned friend says, that D2 is holding assets as a nominee for D1, then these rights would encompass D1's rights to demand that the relevant assets be delivered up to him. But Your Excellency, that just begs the question, what obligations? It imports the concept of a nominee, which we know the UAE law does not have. There's no authority cited for this, no foundation in the expert evidence. It's just asserted. There is no cause of action identified. No attempt is made to formulate what this claim would look like, despite 2 letters on this very topic. So I can take that quite quickly, but in any case, fatal to this route as well, I say, is that vision was incorporated a long time before Mr. Gupta ever did business with Trafigura. There's no reason to think that in 2016, when this company was set up, that there was some amorphous nominee relationship, however it said that would arise under UAE law. Just on that point, I'll come on to all of the facts, but one point that might be worth highlighting is that at the time, certainly, Mr. Gupta did have his own companies in his own name. He wasn't just stashing all of his companies in his wife's name or someone else's. We see that from M3 in the bundle, page 2413. There's a letter from Mr. Gupta's chartered accountants, which assesses the statement of his net worth at the time. Now, I don't rely especially on the values that are ascribed to any of these companies or anything of this kind, but what it shows is that correspondence between Mr. Gupta and his own chartered accountants assessing the value of economic interests in UD Holdings Limited, PG Traders, and his own personal assets, and they're very substantial sums. Now, this is dated in March 2018. So there's just no reason to believe that at the time that Vision set up in 2016, it's secretly, for some reason, set up as Mr. Gupta's company. There's just no evidence of that at all. Much less that Vision didn't hold its own assets, but in fact held them as a nominee for Mr. Gupta. Now, the light touch approach that has been taken to UAE law really just exacerbates our concern that Trafigura does not actually intend to take any of these routes. Rather, what we fear will happen is that any order that Your Excellency makes will be taken on shore to obtain a provisional attachment on the back of that interim order, and then that will set up the basis for direct enforcement action. And it will just be said to the Dubai court, there we are, we've got an attachment over the properties, and now that we've enforced the substantive judgment, we'd like to auction these properties, please, and have the money transferred to us. Now, there's some quite alarming submissions that were made yesterday about this. My learned friend said, well, this court needn't be bothered about how its order is used in the onshore courts. Whatever routes are open in the onshore courts are open, and that's the end of the matter. For Your Excellency, it obviously is a matter of concern that this court's orders are not used to obtain superior relief, especially in circumstances where it rather appears that that same manoeuvre has already been tried in bringing the English court order onshore to the DIFC. Now, a core part of my learned friend's submissions yesterday on this was to say, well, the enforcement action is not even available, so you can't infer anything from the fact that we haven't taken these actions already. Of course, we haven't done so. We haven't yet recognised the foreign judgment. And my learned friend went so far as to say that my submissions were nonsense and a misunderstanding of the UAE procedures. Your Excellency, that is wrong. These actions that they have proposed are not enforcement remedies like a charging order. They are not dependent upon a judgment having been obtained. They are substantive claims, much in the same way as a claim under Section 43, or a subrogated claim or a claim for a declaration as to a sham contract. Just to make that good, if we go back into R18 in the bundle, page 5294, this is about indirect claims. This is back in the Ministry of Justice commentary. We see the article is quoted as 392, and then underneath that, the commentary at 2.0582. It says this, from the creditor's point of view, all that is necessary is that there should be a debt without it necessarily having fallen due for payment yet. That's because an indirect action, as between the creditor and the debtor, is a preservatory procedure that may be taken in respect of a deferred debt or a debt subject to a condition. So it's not even necessary to invoke these procedures that the debt has fallen due, much less that there be a judgment upon it. Equally, the same thing applies in respect of the Paulian actions. We saw a moment ago when we were looking at the articles that it's available from the moment that the debt arises, and the more coercive restriction is imposed from the date the claim is brought. But it's perhaps most starkly illustrated by the fact that it is subject to a limitation period that runs from the date the claimant becomes aware of the disposition. We see that in this same document if we scroll through to page 5299. It's Article 400. This is in the same run of articles dealing with the Paulian action. And the limitation period is that no claim for a declaration that a disposition is ineffective shall be heard after the expiration of 3 years from the date on which the obligee learned of the cause, rendering that transfer ineffective. Now, this is in fact common ground. We can see what my learned friend's expert says about this in R 3, R4 rather, of the bundle. And it's at page 4911. Paragraph 5.11. So we've taken the point that the Paulian actions are time barred because the transfers occurred from P prime to Vision more than 3 years ago. And in response, the point that's taken is that M & Co are instructed that Trafigura did not and could not reasonably have become aware of the P prime to Vision transfers prior to August 2024, when the Dubai Land Department records came to light through a search of the database. We haven't independently verified that date. Now, we've said, well, it's not clear, what, in fact, that they couldn't reasonably become aware before then. Not clear why searches were not done earlier when the proceedings were started back in 2023. But in a sense, that's all beside the point for the present purposes, because it's quite clear that an action not only can be commenced now and could have been commenced long ago, but indeed that Trafigura are at risk of that action becoming time barred if they don't pursue it promptly. And it may already be time barred now. So it's just wrong to say that these actions are not available until judgment is obtained. And we are concerned that many years have gone past. Trafigura hasn't taken any of the steps that it says it will. And we invite Your Excellency to treat with some caution the shifting case on UAE law that has continued to travel through the course of this application until it has landed finally in my learned friend's skeleton on a basis that's not substantiated properly by authority. And we just say all of that is totally unarguable and a reason why travel relief should not be granted at all. Now, even if, contrary to all of that, my learned friend can show Your Excellency that there is a route to enforce against the shares in Vision, it doesn't follow that this court should then grant an injunction restraining all the dealings in Vision's assets. That would be a highly unusual form of relief. As I said before, Trafigura's interest is in preserving the value of the shares in Vision, not in locking up all of its dealings. There's a useful discussion of the principles on this question in FM Capital and Merino, which is in the authorities bundle at tab 31, page 794. We can see from the head note, the defendant was found liable in bribery, made subject to a freezing order, and that order was extended to the assets of 3 companies in which he was 100% shareholder and director. And the defendant applied to vary the terms of the order to remove that provision, and the application was granted. So this case is not just about the meaning of a freezing order, it's about whether it's appropriate to grant injunctive relief of that kind. There's quite a helpful discussion of the authorities. That starts over on page 800, starting down by letter G, paragraph 16. And the first authority at paragraph 17 is Group 7. That's a case we see over the page at 18, where the third defendant was the sole shareholder and director of a company called Wealthstorm. One of that company's assets was a debt owed to it by a third party, and the judgment, the case concerns the alleged contempt in compromising that debt. So that case, Group 7, is mainly concerned about what the freezing order means and whether it in fact extends to those assets. But in the course of the discussion, Mr. Justice Hilliard makes some useful explanation about the circumstances in which the court would make a freezing order extending to companies' assets. And we see that over the page at page 802. That's at paragraph 23, quoting paragraphs 80 through to 82. So when there's strong evidence that the respondent has or is likely to have assets in a non-trading body corporate in which he owns and controls, does not have any active business, which are in truth no more than pockets or wallets of that respondent, an extension to the ordinary form may be justified. Since it may be that the assets held within those corporate pockets ultimately be required to be available for the purpose of enforcement, such assets, relief designed to preserve such assets may be appropriate. Exceptional circumstances would still have to be demonstrated. In many cases, restraint on any transactions diminishing the value of the respondent's shares may well suffice. The next paragraph, the order may be crafted to restrain dealings in the assets of body corporates having no substantial trading activities which are wholly owned or controlled. And at the end of that paragraph, with any appropriate exceptions to allow for trading in the ordinary course of business. And over the page, however, as has often been emphasised, a freezing order is even in its standard form, a substantial invasion of the respondent's usual rights, to be made only to seek to ensure that the effective enforcement of orders of the court is not deliberately thwarted. Obviously, any extension in its application to legally separate third parties, which may be envisaged in ways that cannot necessarily affected in ways that are not necessarily or comprehensively envisaged, can only be justified in exceptional circumstances. Now, that reasoning is adopted by the Court of Appeal in Lactamia Shipping, and the rationale for that is set out below paragraph 26, where Lord Justice Tomlinson explains that, in effect, it's all because disposing of assets at an undervalue is not in the ordinary course of business. And we see over the page at paragraph 27 that in that case, what it justified was the imposition of a notice requirement. And that's because the claimant's interest is in ensuring that the asset against which it can enforce, which is the shares, are not reduced in value. Its interest is not in restraining movements of the company's assets for value in a way that does not reduce the value of the enforcement target. Then again, at the bottom of page 804 and over the page, Sir Bernard Ricks explains, as quoted at paragraph 42, if a claimant wishes to freeze assets of a non-defendant, he must be either prepared to make a sufficient case that the company concerned is just the money box of the defendant and holds the assets to which the defendant is beneficially entitled, and/or has to make that private company a defendant itself under the Chabra jurisdiction. Trafigura has chosen the first of those two courses. Vision has not been joined, has no longer said that Vision holds its assets as a nominee for Mr. Gupta. The Deputy Judge then summarises the principles over the page at 805 from paragraph 32 onwards by reference to those authorities. And the key ones for our purposes are over the page at 806, 4 and 5. 4, if a defendant exercises control over the assets of a company in which they're a shareholder, then they may be enjoined from disposing of company assets in a way that affects the company's value. We see that the usual mechanism for that is a notice injunction. And then 5, there may be occasions when the freezing order could be expressed to relate to the assets of the company, but that jurisdiction is to be exercised only exceptionally, where in truth the company's assets are the respondent's assets. Of course, all of that is in the context of a jurisdiction where there is such a concept as a nominee. We don't need to turn it up, but the same principles and the same cases are examined quite thoroughly in the judgment of Mr. Justice Foxton, as he then was in Civiello and Brodel, That's in Authorities Bundle 39, and the relevant paragraph is 25 at page 1020. Now, my learned friend, for his part, relies on the decision in this court in GTC Trading. That is in his, I'm not sure it's in anyone's skeleton argument, but it was added to the bundle. That's at Authorities Bundle 53, page 1564. This was an application to discharge an injunction by two NCADs, and that's R2 and R3. R2 is a company, R3 is an individual. Over the page, over 2 pages at paragraph 7, the judge quotes an article by Stephen G. on the Brodell decision. And I note that that article is highly controversial. It's one in which Stephen G. expresses the view that Mr. Justice Foxton's decision is wrong. But the judge in this case doesn't need to resolve that tension, because it appears that it doesn't really make any difference whether it matters that the company is trading or has creditors of its own or not, because from what we can see from the facts, if one looks at page 1567, at subparagraph H, we see that the audited accounts for the company respondent R2 revealed that it was managing properties of a related party, one of the defendants, for rental income. There's various descriptions of things appearing from those accounts, but what one does not see anywhere in this judgment, there or elsewhere, is a suggestion that that company had creditors. So it would appear that this is one of Mr. Justice Hilliard's pocket or wallet or money box cases. There's certainly no need in this judgment to resolve any tension between Stephen G's article and the views of Mr. Justice Foxton and the Court of Appeal. So just to draw those threads together, at the threshold, Trafigura needs to show that it can establish a route by UAE law under which it can enforce a judgment against the shares in Vision. We say that is untenable. But even if it can, it then needs to show that Vision is not a genuine trading company with genuine creditors. And even then, an order restraining an agent of the company, that's Mrs. Gupta, from exercising her powers to cause the company to deal with assets would be exceptional. The usual mechanism for that would be a notice injunction in order to prevent the shares being diminished in value, rather than locking up all of the company's assets. And really, this is all perfectly consistent with the views expressed by Justice Sir Andrew Moran in the case that we saw earlier, adopting Your Excellency's reasoning in LXT Holdings, where it was regarded as exceptional and intrusive to be making injunctive orders that seize up the company and prevent it from dealing with assets, rather than just preserving the value of the shares against which Trafigura says that it can enforce. Now, I'll come on to the prejudice and so on in due course, but just to deal with one point now, it's said against me, well, that's all right. The Vision and Mrs. Gupta can just ask us for permission if they want to deal with any assets or sell anything. And the reality is that that proposition is just totally unreal. If we see the way that this application is unfolded, the incredibly hostile approach that Trafigura has taken in the onshore courts, it is clear that Trafigura is out for blood. And any request for any change will be met ferociously with opposition, with document requests of all kinds, in the end, it would be necessary for Mrs. Gupta to find funding to make some application to this court at cost risk. And it causes a severe prejudice to an attempt to deal with assets in order to satisfy the demands of creditors that could be easily catered for by a notice undertaking, such as that.
In terms of the relationship with the UAE processors, you say they're not amenable to this kind of relationship asserted by Trafigura, and you say that's an answer to you put that as an answer to the Chabra jurisdiction, or the Chabra power, I should say, in respect to make an order of the kind that is being made, because it's conditional upon enforceability in some place, in this case the UAE, through the conduit jurisdiction. Now, that can be put as, I suppose, an absolute answer, or it may be that there is a qualified answer to that. There may be a pathway which is compatible with the notion of enforcement of the freezing order itself in relation to assets, which could be affected by some kind of supervisory, I think you might have mentioned this before, some kind of supervisory function for the DIFC court and embedded in the freezing order. That is, you can't go off to the UAE courts without, on the basis of this freezing order, unless you get the consent of the parties or the permission of the court.
Well, Your Excellency, I'm sorry.
Or does that get us into interjurisdictional battles?
Well, Your Excellency, it is obviously right that Trafigura must not use any order that Your Excellency grants as a lever into enforcement in the onshore courts. Cannot upgrade that in the onshore courts as though it were part of a route to enforcement rather than a way to preserve assets. But it must mention that also.
Enforcement in relation to the preservation of assets might be a pathway, mightn't it? Not characterization of Mrs. Gupta as a judgment debtor with some kind of debt. She's not in that position. She's in the position of somebody who's subject to this freezing order.
Well,
and that's
that is, yes, that is certainly true. And one of our concerns is that any order that is made will be used before the onshore courts to suggest that the question of amenability of these assets to enforcement of the judgment or their ownership by Mr. Gupta has somehow already been determined. And so we won't see any of these indirect actions or Pauline actions and so on and so forth ever actually pursued. It will be regarded as a fait accompli. But in my submission, that also just puts that one has to be careful not to put the cart before the horse, because in order to obtain a Chabra injunction, my learned friend has to satisfy Your Excellency that there is a path that he can pursue independently of any injunctive relief granted by this court in order to enforce against these assets. And if he cannot show that to Your Excellency, then there is no reason to believe that he will be able to enforce against the assets, and therefore no basis on which to preserve them for Trafigura's benefit.
The pathway for enforcement must be on the basis that somehow there's a right of recovery against Mr. Gupta, which could be pursued in the UAE on the basis that Mrs. Gupta is, falls into one or other of these categories.
That's right, and not just Mrs. Gupta, but specifically the way it's now framed, that what Trafigura needs to show is that they could go to an onshore court with the English judgment, whether enforced directly or via this court, and that it could execute against the shares in Vision, have them auctioned and receive the proceeds. And it needs to show that it can do that without the freezing injunction. It can't use Your Excellency's freezing order as part of that machinery. That is just totally the wrong way around.
Yeah. Yes, all right. I suppose if there were No, I'm thinking about the impact, the enforcement of the freezing order itself, as distinct from the debt which is given, the judgment debt which has given rise to the freezing order. Whether there's some sort of lesser level of enforcement that would be open to them in the UAE courts. In relation to protection of assets.
Well, of course, if a freezing order is granted,
yeah,
there'll then be questions, which I'll come on to address, about whether that can be enforced in Dubai and how. But the anterior question, which Trafigura must satisfy before there's even a basis to grant a Chabra injunction in this court, is that they can enforce. Yes,
I understand that.
Yeah. Now, okay. That's what I wish to say about the UAE law roots. And turning to the evidence, in a sense, I say none of this really matters very much, because the points that I've mentioned already really are the beginning and the end of it. But can I start on the evidence of what is common ground? First, it's not in dispute that Mr. and Mrs. Gupta have been married for 20 years, more than 20 years. And that matters quite a lot, because all of Trafigura's evidence rests on various connections between Mrs. Gupta and Vision on one hand and Mr. Gupta on the other. So, for example, it said, oh, it's all very odd. Mr. Gupta had a listed address at one of the Vision properties, or that Mrs. Gupta leased 2 of the Platinum Tower units to Mr. Gupta's company. Now, none of that is odd. It's perfectly normal for married couples to have economic transactions between them. Second, it's not in dispute that there exists an Indian cultural practice of street hand. Now, my learned friend was quite glib about this in submissions, but the point is not that Indian law somehow applies. The point is that there is an established Hindu cultural practice which involves giving substantial gifts to married women, which are genuine and the sanctity of which is jealously preserved. And the reason this is relevant is that Trafigura says, well, when Mr. Gupta has given gifts to Mrs. Gupta over the years, or when she's received assets from his family or so on, then the inference must be that they're really owned by Mr. Gupta. So that just doesn't follow, even normally, but especially not against the background of that accepted cultural practice. Now, my learned friends indicated that they would adduce expert evidence in relation to that when they sought an adjournment, but that was never forthcoming. And so that is not in dispute. The third thing that is not in dispute is that Mr. Gupta did gift Villa K1 to Mrs. Gupta in January 2017. Mrs. Gupta explains that in her witness statement openly, and explains that that is part of the street hand that she has been granted over the years. There's nothing untoward or shady about how that was done, properly recorded with the Dubai Land Register. The value of the property was recorded, the land tax was quite properly paid. And that occurred 1.5 years before Mr. Gupta's companies had even begun trading with Trafigura. So my learned friend cannot and does not say that that gift was designed to put assets beyond the reach of creditors, or at least beyond the reach of Trafigura. Now, what he does say, perhaps we should see it in his skeleton argument at page 13. Paragraph 22. At the end of paragraph 22, the criticism of the street hand evidence says she's unable to specify a single one of those gifts, when it was received, from whom, and how much it is worth. Then the next paragraph, it is common ground that D1 gifted this property to D2 in January 2017. So those paragraphs are not talking to each other. And if we go over to page 17 of the skeleton, we see what's said about this transfer at paragraph 27 at the top of the page. It's common ground that this asset was gifted by D2 to D1, that is certainly consistent with her holding property as his nominee. For present purposes, it is certainly sufficiently arguable that she is. Why is it sufficiently arguable? It's not even explained. The evidence just assumes that when Mr. Gupta gives property to Mrs. Gupta, he doesn't actually mean it. That's not a safe inference at any time since the Married Women's Act was passed in England. It's not a valid assumption against the cultural context that I've described. Now, turning then to the specific evidence about the vision properties, the points that my learned friend takes in his skeleton broadly fall into two categories. First relates to the acquisition, the second relates to what he says various connections between Mr. Gupta and the properties. Now, the case on us in relation to the acquisition was put in Laken 8 as that they were acquired from P prime at a significant undervalue. I won't turn it up with references, Laken 8, paragraph 8.2, C14/883, and it's elaborated in some detail at page 893. So that is the case that Mrs. Gupta has met in Gupta 4, and there are three answers to it. First, the DLD, the Dubai Land Department, has an automated system which prevents under declaration of property value, and that's because fees are charged. Stamp duty or the equivalent is charged on the price. And the existence of that system is not in dispute. What Mr. Wiln says in response is that it doesn't pick up whether there are transfers between related parties. And he notes one transfer, which is in the data, is very out of line, and suggests, well, there we are, the system just doesn't work. But we don't know anything about that transfer, and so it's not evidence of anything. Second, there's a dispute about whether the sales are in fact on the trend line. And Your Excellency will have seen, perhaps in my skeleton argument, a reference to the tables that have been produced by Trafigura in evidence. And there's a suggestion that the sale prices for these vision properties was as much as 71% below the average at the relevant time. I'm not going to trawl through all the points in my skeleton argument, but I do invite Your Excellency to treat those tables with great caution, because they are inaccurate and misleading in the sense that they omit at least one sale, and they are also cut off at a very convenient point in each case in order to include higher values and exclude lower ones. The much better guidance is just taken by looking at the data, which is helpfully collated in a graph on the publicly available site and on which both parties rely. For Platinum Tower, that's at M71, page 2952. And so what we see here is a Dubai Interact sales timeline for all of the units in Platinum Tower. And there's various blue dots, and you can see the general trend that things are increasing in value over time. And one can see just by looking at this graph, when we're talking about sales for 500,000 in September 2020, for which there's no data, January 2021, and then a couple in May 2021, that they're very much on the trend line. And that's there's information in the bundle about the recovery of the property market after COVID, but one doesn't really need to go any further than this. Now, there's another point taken about, it said, well, the increase in value compared to the estimates given by Hilal in 2024 is implausible. Well, Hilal estimated that the value of these properties was 1.8 million in September 2025. We see on the far right-hand side, I think the graph probably cuts off before we get to September 2025, but we can see that the values are well and truly reaching up and above 1.8 million at that stage. which is entirely consistent. It would be unsurprising if a property worth 0.5 million in 2020 or 2021 was worth 1.8 million in September 2025. It would be entirely consistent with the dots that we see on the graph. And we have the equivalent data for Concord Tower at page 2957 behind, I think, the next tab, M72. Now for Concord Tower, there were two sales. Sale for 350,000 in January 2021 and a sale for 500,000 in September 2020. And again, I say that a simple visual analysis shows that these are not out of line with the trend. Now, one of the problems with Mr. Wilm's table is that on the Concord Tower side, it only adopts the lower of those two as the comparator, ignoring the $500,000 dirham sale. It also omits certain of the sales that are in the period to which the table relates. The reference, I'm not going to go through them all, the references are all in my skeleton argument, and there is a version of this data that shows the individual sale values and dates behind tab U6 in the bundle. The references to that are all given in my skeleton argument. And so I say there's really nothing in that allegation. But if that weren't enough, again, when seeking an adjournment, is the third point, when seeking an adjournment, Trafigura indicated that they were going to obtain valuation evidence. Perhaps if we just look at that, it's at F1, page 1375 of the bundle. You see paragraph 40 underneath the header valuation evidence. And Mr. Wilm refers to the evidence of valuation set out in Mrs. Gupta's witness statement over the page at paragraph 41, halfway through that paragraph. In order to interrogate the position, Trafigura intends to seek valuation advice in relation to the property market for the sale of comparable properties during this period. Such advice and any expert valuation evidence which Trafigura wishes to adduce as a result of taking such advice cannot be prepared within the time presently available. Now, no such evidence was served, despite permission for expert evidence being granted and the extension being granted for that purpose. And we can only infer that that advice was taken and that the advice did not merit putting before this court. And so then I say it's quite striking that my learned friend's skeleton argument at page 17, under paragraph 29.2, says that Mrs. Gupta hasn't produced evidence of actual sale prices during the period. If Trafigura had wished to dispute the valuation, then it was open to it to do so. All this is a very fragile basis on which to invite this court to interfere with Vision's property rights. So that's the undervalue point. What's the second category? It's the connections. We see those on page 18 of my learned friend's skeleton argument. For a new heading. In paragraph 34, there are various connections in relation to the properties of Mr. Gupta. 34.1 lists 5 points, but they're really all the same point, and that's that Mr. Gupta and his company UIL have given an address at 1101 Platinum Towers Well, that's been explained and had been explained even before Mr. Willen's evidence came in by Mrs. Gupta, who explains that 1101 and 1102 were leased to UIL commodities. That's in C171149. It's also clear from publicly available information on the UIL website, which is at M282830. So there's nothing concealed or strange about that. Mrs. Gupta confirms in any event that the other 8 were leased to different companies not associated with Mr. Gupta. And then for Concord Tower over the page, there's a single reference in that Mr. Gupta has listed an address for a Singapore company at Concord Tower. Mrs. Gupta explains that she understands that that has just been carried forward from old records. Again, it's said that that's all a giant lie because the document itself is dated in 2024. But and this document, perhaps it's worth turning it up, is M492831. And one immediately sees the nature of the document this is. It's a computer-generated, it says at the bottom of the page, filing made on behalf of this Singapore company. There's no reason to think that Mr. Gupta is sitting at a computer making individual corporate filings on behalf of his company. This will have obviously been done by some administrative person responsible for these things. And it's, as Mrs. Gupta explains, simply been carried forward. Someone's failed to check the address. There's no reason to doubt that evidence. It's certainly a fanciful basis on which to say that Vision's properties are not their own. So that is the sum of the evidence in relation to the properties. It doesn't come close to showing a basis that they are in substance owned by Mr. Gupta. Instead, there is then a broader attack on Vision and Mrs. Gupta, and there is a list of at least 35 issues, which I dealt with in my skeleton argument, said to show various issues with Vision more generally or other assets of Vision, Mrs. Gupta's history and so on. Many of these have now fallen away. I'll deal briefly with those that were made orally yesterday. The first, it said there's a disparity between Mr. Gupta and Mrs. Gupta's disclosure. The broad thrust of that was, well, Mr. Gupta was engaged in a very lucrative fraud and he doesn't have any assets. Now, Your Excellency wasn't shown any evidence in relation to any of that. Now, the transactions to which the English claims related, it's quite important to appreciate, they were transit finance transactions. So Mr. Gupta is not selling outright to Trafigura. Trafigura is financing the nickel. The losses are very large because when the music stops, Trafigura is holding title to them. But that doesn't mean that Mr. Gupta has been selling hundreds of millions of dollars of aluminium at nickel prices and keeping all of that cash over the years in the way that Mr. Peters suggested. Now, by contrast, then it's suggested, well, there's a great disparity between the asset disclosure. I'm not quite sure what that was based on, because if one looks at the asset disclosure given in these proceedings, at least, which is in the bundle, that is, of course, only related to assets in the UAE. And the same thing is true of Mr. Lakin's affidavit, which discusses assets in the UAE. So I'm not in a position to say that that's wrong, but I haven't seen any evidence to support that assertion, and neither has Your Excellency. But in any case, it's not quite clear what the implication is, because quite a lot of the points that were being made are all about Silver Star, much more valuable asset than those we're concerned with today. And that point doesn't really advance Trafigura because it's just the same point that was made before His Honour Judge Pelling in 2023. And His Honour Judge Pelling found at that time it was extravagant to extrapolate that to all other assets, and it remains the position now. The Vision properties are, of course, worth vastly less than Silver Star. The second broad area of attack is about Mrs. Gupta's background It said, well, there's no evidence that Mrs. Gupta was anything more than a HR assistant. She was entirely dependent on her husband. Again, that's not a fair characterization of the evidence. Mrs. Gupta has a degree in economics and an MBA. She is a capable, enterprising woman. She founded GG Corporation, which we've seen. Now, it was said about this company, oh, well, it didn't make much in the way of profits. But the point about this is that it's a business that was established 16 years ago, long before Vision, and it follows much the same structure as Vision ultimately did. And in particular, it's engaged in trading with high revenue but low profit, it's small margins. It's exactly consistent with Vision's business model. And that's also consistent with Mrs. Gupta's evidence. And one of the things that my learned friend says in his skeleton argument was that, oh, Mrs. Gupta claims to have run a company that was producing $15 million in revenue. All she produces is a record of $18,000 in profit. In essence, it's just apples and oranges, not comparing the same thing at all. Now, it's of course unsurprising that Mrs. Gupta should have derived some assistance from Mr. Gupta. And Mrs. Gupta is entirely candid about that. She says in paragraph 20 of her witness statement, C171134, that Prateek offered me assistance and advice as necessary. The fact that a husband helps his wife get on her feet with her business doesn't mean that he owns all of her assets or those of her company. Third, it said, well, Trafigura knows quite a lot about metals trading. It couldn't find any public information. Well, that's not evidence that the business is fictitious. In effect, it was just inviting Your Excellency to take Trafigura's word for it. Mr. Obaid, for his part, in his expert report, explains that a private JAFSA company conducting back-to-back international trades through commission-based traders may well leave a little public footprint. That's in paragraphs 28 to 30. Fourth, it was suggested that Mrs. Gupta's asset disclosure is not consistent with the trade debtors that were recorded in the 2023 financial statements. And the suggestion seemed to be that the trade debts owed to Vision recorded in the financial statements are not genuine. This is part of Trafigura's case that Vision has never really been doing anything at all. Your Honour was specifically told that the 2023 draft financial statements were produced by Mrs. Gupta herself, and it was suggested that that was just all made up. Your Excellency, this is a bad point. There are audited accounts in the bundle for 2019 through to 2022. The reason that the accounts begin in 2019, Mr. Obaid explains, is that that's when VAT is brought in the UAE, and so it becomes necessary to have audited accounts. All of those accounts from 2019 onwards refer to very substantial trade debtors. And I'll just give Your Excellency one reference, we don't need to turn it up, but the 2019 accounts, the earliest of them, are at P404636. And that's, of course, years before Trafigura brings any claim. There's absolutely no basis to suggest that this is all fabricated and there's never been any trade debtors despite the audited accounts, which record that there were. The fifth area of attack is about the financial statements themselves. The main point taken yesterday by my learned friend was that the accounting entries don't explain how the properties were acquired. Now, that was a new point, as far as I've been able to tell, taken by my learned friend on his feet. It's not dealt with anywhere in the very thorough expert report. And if my learned friend perhaps has forensic accountancy skills that exceed my own, then it is at very best a point about bad accounting. It doesn't say anything about who owns the properties. Now, there are various other points taken in the expert reports. They all concern the quality of the accounting, in effect. In my submission, they go nowhere. They're dealt with in the obeyed report. In view of the time, I'm not going to take Your Excellency through all of that granular detail now. The sixth area, which my learned friend pressed yesterday, was about the assets of Vision, the various points made about Hangji and Crytel, two companies which Vision owns. These, I say, are bad points for two reasons. Firstly, really this doesn't tell us anything about who owns the vastly less valuable properties that this application is concerned with. It's very much in the Silver Star line of thinking. But second, the central point in the BRG report is that Hangji and Crytel are not worth anything like what's recorded in the accounts. So the main point taken by BRG is that the growth of Vision is mainly fueled by an unreliable capital gain of Hangji and Crytel. So what the expert is saying is that actually these companies are not worth anything like what's recorded in the accounts. Yesterday, my learned friend saying, well, they're all very valuable. So that must mean they're owned by Mr. Gupta. I just can't have it both ways. But in any event, it's not a fair criticism of Mrs. Gupta because she has always been transparent about the illiquid nature of these investments and the difficulty with valuation. We see that in her English asset disclosure right back in 2016, which is at M162568. The asset disclosure starts on 2567. The table that Your Excellency has probably seen a few times now, M16. And then over the page, Mrs. Gupta is very, very transparent about Vision. Of course, there's no obligation in the order to provide chapter and verse about Vision's assets. The obligation is to provide value of her own assets, but she does nevertheless do so. Over the page at Roman numeral 2, she explains Vision acquired minority interests in two listed companies. The acquisition of these shares was made prior to the listing of these entities. They've not been publicly traded. Current market value is approximately 500 million, but in management view, the market value of these shareholdings is not accurate or a complete indicator of the shares as a whole. And we see the same thing recorded later in her subsequent asset disclosure and in the financial statements about the illiquidity of these transfers. And we're all familiar with the idea that some companies based on small capital raises are given massive values that actually doesn't correspond to what they're really worth. And so Mrs. Gupta has been totally upfront about all of this. It's not a fair criticism, and it certainly doesn't show that Vision is not owned by her. Now, where all of this ultimately goes, finally, there was a seventh point about the bank account. Said, well, Vision couldn't possibly have operated at the scale that it did without a bank account until 2020. But the obeyed report makes clear that these trades are back-to-back or commission trades, where what Vision is receiving is the commission. It's an intermediary. So the sums are very large, which we see recorded as revenue, but the margins are relatively small, relatively speaking. And it's only the margins which are actually paid. Now, where all of this ultimately goes, of course, it's also a sole shareholder company. If it's using Mrs. Gupta's bank account informally, that doesn't mean that it's not a genuine trading company up to that point. Now all of this, in the end, all of this evidence ends up with a conclusion in the BRG report. It's suggested that there's a risk of round-tripping fraud, they say. Now, the purpose of a round-tripping fraud, of course, is to give an inflated view of genuine economic activity. And the purpose of a fraud of that kind is usually to defraud someone who is involved in the company, either a creditor, a lender, or other shareholders who are advancing funds or giving personal guarantees in the kind. But what is seemingly missing from the BRG report is any reason why Mrs. Gupta would be engaged in that sort of elaborate fraud. Vision doesn't have any other shareholders. It doesn't have any bank creditors. So there's no reason why Mrs. Gupta from 2016 onwards, for many years, would be engaged in this elaborate fraudulent activity to create the illusion of a genuine company. There are nowhere in the BRG report is there a single round-tripped transaction identified. So it's just pure speculation, and the Obeid report makes that point.
When you use that term round tripping, is that analogous to the term I think sometimes used churn, that is creating apparent transactions or apparent economic activity which is not actually going anywhere?
That's usually the nature of those frauds. Yes. So what happens in a paradigm round tripping fraud is that there are fictitious transactions where money is sent out and then makes its way back under cover of some other genuine transaction. And the reason why one does that is so that one can skim money off the top. And so you create the illusion of a genuine business. You go to banks and say, look how wonderfully well my business is doing. Please, can you extend me very large loan facilities? And the facilities keep going up and up and up. And you keep skimming off more and more and more. Perhaps you get some personal guarantees for some passive shareholders who can be left to hold the baby at the end. And then you disappear when the music stops, along with all the funds. And there are a number of cases in the UAE where that sort of fraud has been perpetrated. But this just bears no resemblance to that. There's no reason why Mrs. Gupta would have done it. There's no suggestion that she'd benefited from any fraud of that kind in that way. But it's also notable that terminology and that hypothesis hasn't even made its way into my learned friend's skeleton argument. As I understand it, it's not really any part of his case that Vision was involved in round-tripping fraud. He says to the contrary, I think, that it wasn't that the transactions were being conducted to create an inflated view of genuine trading activity. It's just that they didn't happen at all. So one sees in his skeleton argument a reference to purported financial statements. I think the suggestion now is that these documents are all just fabricated. And in a sense, that's of course the easy allegation to make. Oh, all these documents are just false. They've all just been invented. But Your Excellency, the list of documents that have to be false for Trafigura to be right is getting quite long. And they include now financial statements prepared contemporaneously, we say, by 3 different sets of auditors. We're just veering into totally fanciful territory. Now, even assuming for a moment that Trafigura could establish that the entire metals trading business of Vision is a fiction, and that these documents have all been created after the fact, signed off by third-party auditors, never mind the bills of lading that are in the bundle issued by third-party shippers based on third-party information, which all tally with the invoices and so on. Never mind all of that. The whole metals trading business is a fiction. Even if that's right, why does it follow that the investment properties held by the company in fact belong to Mr. Gupta? And it's just worth underlining again the properties that we're talking about. We're talking about Platinum Tower units that are acquired for about £100,000 each. Concord Towers units that are acquired for about £172,000. These are not big figures. His Honour Judge Pelling was not willing to accept that the funds in the client account of Mishcon Duraya belong to Mr. Gupta. Your Excellency should also not accept that there's really any reason to suppose that these properties do not belong to Vision or do not belong to Mrs. Gupta. Now, I've veered into using this language of do not belong or nominee and so on, but that's really because it's the only way to understand the way that Trafigura has put its case. And I don't, by doing that, for a moment, step away from the analysis of UAE law that I invite Your Excellency to stick to rigorously when assessing whether there really is a way for Trafigura to arrive at the destination that it wishes.
So what if there is, we have the expression in Australian statutes, and I imagine others, of arrangements and understandings, and you can have an understanding, for example, which has no legally binding effect. One person holds an asset, and the understanding is that if the other person asks them to do something with it, they'll do it. There's nothing written down, there's no contractual obligation, there's no equitable, let's assume no equitable interest, just used to be called sometimes a gentleman's agreement, which is described as an arrangement which is not an agreement between two persons, neither of whom is a gentleman.
Yes.
Well, I'm looking at the possibility of something that is below the legal landscape. Does CHABRA engage with that?
It doesn't, Your Excellency, and there's good authority to that. In fact, it's one of the propositions that I stated at the outset that I think is common ground. If it's not, the authority for it can be found in Mr. Justice Foxton's judgment in Civiello and Brodel. He quotes there at paragraph 24, Roman numeral 3, from what his lordship describes as the purest formulation of the enforcement principle by Sir John Chadwick, sitting as he then was in the Court of Appeal of the Cayman Islands. And we see in particular that his lordship explains that it's not enough that the cause of action defendant could, if it chose, cause the assets held by the NCAD to be used to satisfy the judgment. It's not enough that there's a gentleman's agreement. It's not even enough that the CAD could require that gentleman's agreement to be performed. What's necessary is that the court is satisfied, quoting again now from Sir John Chadwick, that there is good reason to suppose either that the CAD can be compelled through a process of enforcement to cause the assets held by the NCAD to be used for that purpose, or that there is some other process of enforcement by which the claimant can obtain recourse to the assets held by the NCAD. So a gentleman's agreement just will not do. Trafigura has to show a process of mandatory coercive enforcement by which it can obtain these assets. Now, that brings me to the question of dissipation and justice and convenience. Of course, my primary position is we never get here because there's no basis for CHABRA relief, no basis to believe that Trafigura will be able to enforce, certainly no basis to find that to the requisite standard given the judgment in Abramenko adopting Your Excellency's LXT judgment. But even if we do get to this point, then the question remains, is the existing undertaking regime adequate to balance the parties' interests? Or should Your Excellency injunct any dealings with the properties at all in the way that Trafigura suggests? Or is there some middle ground that Your Excellency considers just and convenient? A notice undertaking with a notice injunction with a longer time period or further information or so on and so forth. Now, the main point put by Trafigura on the point of prejudice, as I said, is that Mrs. Gupta doesn't really matter to Mrs. Gupta because she's not going to deal with these assets and she can just ask for permission. It'll all be fine. I've expressed my skepticism about that, but in any case, what we see is that Trafigura is trying to restrain dealings with the Schedule D assets at all, and Mrs. Gupta has explained in evidence why that is a problem. In short, Mrs. Gupta explains that Vision has trade debtors that exceed its trade creditors by some margin. And so if the company can be salvaged, then it is potentially a very valuable asset in the order of tens of millions of dollars. But if the assets are all seized up and negotiations of that kind become impossible, even with notice to Trafigura, then there is a risk of material harm. There's a risk that Vision gets put into an insolvency process and that the value is never realized. Now, this narrative, of course, is not accepted by Trafigura. Said like everything, Trafigura says, well, this is all just a giant lie. But we see the trouble that Vision ran into after the Chabra order in 2023 from the contemporaneous documents, because it was debanked by Mashreq Bank once that order was made. The easiest place to see this might
have seen that
yes.
communication, or the quote from that communication.
Yes, it's quoted in Mrs. Gupta's witness statement, which Your Excellency's probably seen. I won't take Your Excellency back to it, but the reference for the document itself is M152565. And the effect of that debanking was recorded contemporaneously in the April 2023 interim accounts. And that's also quoted, Your Excellency will have seen that in Mrs. Gupta's witness statement. Now, the relief that Trafigura is seeking, of course, doesn't have any of the usual exceptions. I've been over that. And for that reason, wouldn't permit dealings in the ordinary course of business, including to pay trade creditors, even with notice. But Your Excellency, that sort of order without an ordinary course of business exception is objectionable for the further reason that we are not even in a post-judgment situation, because Vision is not a judgment debtor, and because the judgment which Trafigura has obtained has not even been enforced in the UAE. And there's of course authority that once in a post-judgment freezing order, one can, under certain circumstances, take out the ordinary course of business exception, because at that stage there's a policy that judgment debts should be paid in preference, if necessary, to other creditors. But there is authority in the English Court of Appeal, a case called Nomihold Securities, that when the judgment has not yet been enforced, then we're still in a pre-judgment situation, because there's no judgment that's been made in this jurisdiction. We don't have to go to it. The reference for it is at 55. Authorities Bundle 55, page 1616. That's a case about an arbitral award, but the position is the same. If there's a dispute about the enforceability of the judgment or award, then you're just not in post-judgment territory. And now my understanding is that Trafigura has brought a claim to enforce the English judgment. My understanding is that that claim is being resisted. I'm not instructed in those proceedings, so I don't know the details, but there is at the moment a dispute about the enforceability of that judgment. In any case, of course.
What jurisdiction?
In the DIFC.
Yeah, okay.
But in any case, of course, that judgment's not being enforced against Vision. Now, finally, on the topic of relative prejudice, before I move on to the various breaches that are alleged, it's said that the existing regime is inadequate, and Your Excellency rightly asked yesterday whether the notification regime is inherently ineffective. Now, the answer to that is no. And for that, one needs to look not only at what Mrs. Gupta has done, but what Trafigura has done. And again, Your Excellency has seen the various notices. I won't take you back to them all, but it might be useful just to give the chronology. The first notice was given under the regime in relation to the discovery properties in May 2024. Stevenson Harwood, that was the 28th of May 2024. Just give the reference, it's K62127. Stevenson Harwood didn't even respond to that notice until a week later on the 5th of June 2024. That's at K52125. So that's the first episode, 72 hours very much allowed to fly by without any action being taken. The next notice was the 1st of May 2025 Villa K3 notice, which I've had quite a lot to say about. As far as we can see, there is no response from Stevenson Harwood in relation to that notice at all after it is given. That notice is at U38034. Then in Mrs. Gupta's asset disclosure on the 21st of May 2025, she intimated that the sale contract had by that point been agreed, as Trafigura had been informed. That we saw in the bundle at B1438. And again, no response at all at that stage. Then through to August 2025, several months later, Mrs. Gupta gives notice in relation to the Platinum Tower units. That is at K152145. We've seen that a few times already. And again, even now, no response is received until a week later on the 3rd of September, 2025. And it might just be worth turning that one up. That's at K20212155. This is a letter of the 3rd of September 2025 from Stevenson Harwood to Hilal. And second paragraph down, on the 21st of May 2025, Preston Turnbull served the asset disclosure. Next paragraph, the claimants have not at today's date received a notice. Further down, we will require, it's unclear whether the sale of Villa K3 has gone ahead. But this is months on from when the notice was given. End of the page, we'll require the following documentation and information on an urgent basis. In September 2025. And over the page, we see they're asking for a copy of the Form F, any final signed agreement, formal third-party bank valuation, evidentiary proof of the money received, dates of receipt, itemised information on how the second respondent has dealt with those monies. It's just extravagant. If she had sold the property and kept the proceeds, they're asking for itemised details about how the proceeds of sale of the property have been spent, along with supporting documents to evidence. So none of that begins to be required by the order. But the point is that it's also not urgent because nothing has been done about these notices for months. So Trafigura complains that, oh, this notice undertaking regime just isn't working. You know, how can we possibly deal with these notices when they come? But the reality is that no objection has been taken until very recently. And even in the most recent notice, when it's issued on the 26th of October 2025, that one's at K232161, the application's then not brought until more than 72 hours have elapsed. And so in my submission, it's rather ill in Trafigura's mouth to say that this regime, having subsisted for 3 years and not having been terribly proactive about responding to notices that have been given, that now it needs to seize up all of Vision's assets and all of Mrs. Gupta's assets without any exceptions and so on, because Mrs. Gupta can't be trusted to give notice. It's just an unreal proposition against the history. Now, against that, I'm going to turn on to the various breaches that are alleged against Mrs. Gupta. I note that it's 1 p.m.
Yeah.
It's 1 p.m. in Dubai, and Mr. Peters, local HR manager, is on to me again. Of course, I'm not sure any of us are actually in Dubai. I'm not, for my part at least, I'm not going to insist on a very long break. I'm in Your Excellency's hands, really. There's still quite a lot to get through, so I think if we could have a shorter break, that would be helpful.
Yes, I was thinking another 15 minutes. Mr. Peters, do you have a problem with that?
No, I don't have a problem with that. Just so people are aware, we've been keeping a sort of an approximate record of who's been speaking for how long, assuming that we go through till what is, I think, 1 p.m. my time. I think Mr. Trotter's got about between half an hour and 45 minutes left for everything, including his reply on the discharge application if he wants to make one. So I just raised that because if he goes much past that, then it's going to be cutting into the time that we've kept ourselves for reply.
Well, that doesn't accord with my timekeeping, I have to say. Yesterday, my record was that the claimants finished at 2:20 or thereabouts Dubai time. And so I was aiming to be finished by the equivalent time today so that I would use my day, or if earlier than that, then I'd reserve whatever gap there was for reply.
Well, I've just seen a note come through that the court reporter needs a longer break. So I'll extend that to half an hour. What I would like you to do in the meantime is to try and negotiate an allocation of the remaining time. I would prefer 1 p.m. London time to be a hard stop, as it's 8 o'clock for me, but if I have to have a bit of flexibility, I will. But bear in mind, everybody, that I do have a very large quantity of written material and summaries before me, so it's a matter of judgment. All right, we'll come back at half past wherever you are. Thank you.
Thank you.
Yes. Yes, Mr. Trotter.
Thank you, Excellency. Mr. Peters and I have agreed that I'll take until 20 past the hour. If I finish before then, I'll reserve any time for any reply on the discharge application at the end.
Okay, thank you.
Now, I'm turning then to the reasons why, against everything I've said, Trafigura says that Mrs. Gupta just cannot be trusted to give notice under the existing notification undertakings. I've already dealt to a large extent with all of the breaches that are alleged, which I say are not breaches at all, and in any event certainly don't indicate any contemptuous disregard for the orders. There are two new points made at this hearing that weren't before Justice Sir Jeremy Cook in relation to Villa K3. The first is that it's now said, the sale contract was concluded before the 72-hour period expired. It's true that the sale contract was signed at 4:30 p.m. on 28th of October 2025. We see that from M40 2720. And so that contract is just within the 72-hour period. But of course, the contract doesn't itself involve any disposition of property. The sale didn't complete and the property wasn't disposed of until the 3rd of November. And if this court had granted an injunction before the property had been disposed of, then of course it would have been held back. Mrs. Gupta may have incurred some personal liability to the sellers, but that would not have resulted in dissipation of the property. Now, there can be a debate about what's precisely meant by the order, but the point for today's purposes is there's no reason to think that Mrs. Gupta, who was not represented at the time, did not honestly believe that she was complying with the notification order by providing 72 hours notice before the completion of the sale.
There may be a case if I were not inclined to continue the freezing order on a varied basis, but not inclined to go as far as the claimants want, to make the notification requirement somewhat more precise and capable of ready judgment as to whether it's complied with or not. It's fairly high level at the moment, isn't it?
Yes, well, there may be some merit in that, Your Excellency, because the current undertakings are extremely vague in the sense that they ask for a reasonable summary, and there's evidently significant disagreement between Mr. Macpherson and I, at least, about what a reasonable summary involves. So I agree that would be open to Your Excellency as one path.
Yeah, all right.
Now, the second new point is about the description of the use of proceeds in one of the notices that was said to be dishonest, and I've already dealt with that in the context of taking Your Excellency through the notices before. The other main category of point in relation to Villa K3 is the underlying sharp trend transaction. Your Excellency's probably read quite a lot about this, so I probably don't need to go back through all the evidence. The explanation is set out quite fully in Gupta 3 and Gupta 4. And then there's been various documents that have been produced in order to make good Mrs. Gupta's account. Those include the sale contract, which is at M10/2497, the commercial invoice, which matches it at M11/2499. And it said in relation to those documents, or at least the invoice, that, well, there's no metadata available. But Mrs. Gupta has explained the position in her evidence. It's not controversial that Vision's staff were engaged on a commission basis. That's recorded in the financial statements, and it's recorded in the BRG report, which is at page 7600 of the bundle. So that's not controversial, and Mr. Gupta explains that there therefore wasn't a central repository of emails where all of these things are kept. She never anticipated that the authenticity of one of these various invoices was going to be impugned at some later stage. Now, there are then also have been produced the bills of lading relating to these individual transactions. It might be worth turning those up. They're at 08 of the bundle, page 3859. And we see that the logistics company, Dongham Logistics, is a Dutch company. Mrs. Gupta explains in her witness statement who that is. They're a Hong Kong logistics firm, as described on their own website, operating in 100 countries, processing 500 tons per day. And there's a link to their website in Mrs. Gupta's statement at C17/1161. Now, there's no allegation that Dongham Logistics is not a legitimate and independent operator. It plainly is when one looks at the website, nor is there any suggestion that the shippers in relation to each of these transactions are fronts for Mr. Gupta, or at least not specifically. I think that was alleged in general terms, but these are not amongst the entities that were the subject, for instance, of the English judgment. And we see there are various of them. Richmond Steel Recycling on this one, go over the page, it's Atlas Iron and Metal. Over the page again, US West Metal, and so on and so forth. Next one is a Canadian entity. There are various third parties involved in the production of these documents, and in all of the voluminous evidence that's been produced, there is no trace of any suggestion that any of these entities are affiliated with Mr. Gupta, or any basis on which to suppose that these documents are otherwise than genuine. So this is contemporaneous documents showing that Vision is trading with sharp trend in relation to shipments that match the invoice and the contract which Mrs. Gupta has produced. So really, I say that is the end of any authenticity challenge to these documents. There has also been some suggestion that sharp trend does not actually trade in copper. Your Excellency may have picked up that Mr. Lakin's 7th witness statement said that there was nothing on Sharp Trend's website that indicated that it was involved in copper trading. Mrs. Gupta addressed that in her witness statement, and Your Excellency may have seen the screenshot of Sharp Trend's website in her witness statement at page 1163. Now, the short point about this is that it's the tab number is C17. The short point about this is that the website only has 5 pages. Only 3 of them are substantive, about us, services, and products. And for reasons best known to them and never explained to us, when Stevenson Harwood captured this page, they decided to only capture about us and services and not the products page. Now, on the next page of Mrs. Gupta's witness statement, she has a screen capture of the details of copper wire scrap that are being traded by Sharp Trend that were present on the webpage at the time that we viewed it once the evidence was in. Now, we've then traced back through what's called the Wayback Machine, which provides snapshots of websites at various times in the hope that there might have been a snapshot of this particular page at some earlier stage. Now, what the Wayback Machine shows is that the products page was there through every iteration of the website. Unfortunately, there is no capture of the products page itself, so we can't see what was on that products page. Now, that's an independent third-party operator, so beyond the control of anyone. But what we do know is that the products page existed at the time of the February 2023 hearing, and that for some reason, Stevenson Harwood decided not to capture it. Now, there's then a dispute. My learned friend's evidence in response has various amateur analytics about website metadata and information and so on. It's all quite difficult to follow. And there's been no expert instructed in order to opine on any of those technical issues. So as matters stand, we're just not really in a position to say what was on the website at the time. But what is undeniably clear is that there is contemporaneous documents showing that the relevant transactions occurred. So that's the underlying transaction. Then there's a dispute about the sale itself. Mrs. Gupta has explained in her witness statement the impact that the Chabra injunction had on the company's operation and the need to negotiate with creditors. Your Excellency has seen that. I won't go back over it all. But then the guarantee, she explains in particular the circumstances in which the personal guarantee is entered into. And my learned friend said yesterday, well, why would Mrs. Gupta put herself on the line for the sake of vision? But Your Excellency, that's not at all uncommercial. Mrs. Gupta is the sole shareholder of Vision. She's trying to rescue what could be a very valuable asset running into the tens of millions of dollars. Why shouldn't she be prepared to put personal assets on the line in order to save another personal asset? It's a perfectly sensible way of trying to keep Vision afloat. And my learned friend's assessment of risk is not one that makes that an uncommercial or dishonest move. The guarantee itself explains that Sharp Trend was alleging that it had a $8 million debt and was suffering additional business losses, loss of opportunity style claims, and it was asserting a claim for $15 million. The guarantee records that Sharp Trend was threatening liquidation proceedings, but was willing to forbear until March 2025. She does give that guarantee. The negotiations do bear fruit, and a settlement is entered into on the 2nd of May 2025, and that document is at U2/8025 of the bundle. And the main point taken about this agreement is that it's uncommercial that funds should be directed specifically to Al-Noor rather than paid to Mrs. Gupta, which was the arrangement that Al Noor, or Sharp Trend rather, insisted upon. But we say that, well, why is that uncommercial? It makes perfect sense for a creditor in Sharp Trend's position to insist on that rather than risk money from a purchaser being snatched by someone else. And indeed, I've shown Your Excellency in the English Chabra order in Schedule C that Trafigura itself insisted on much similar mechanism in relation to loans advanced by Mrs. Gupta for Mr. Gupta's legal fees. They have to go directly to the solicitors, not via Mr. Gupta. And my learned friend made a new point yesterday about this settlement agreement. The suggestion was that Sharp Trend acted uncommercially by settling for one property rather than going after both. I have to say, we don't really understand that. The settlement agreement does not entitle Sharp Trend to go after both. The deal recorded in the settlement agreement is that Mrs. Gupta will market both sets of properties and see which one can be sold first. And nor was it uncommercial to enter this settlement agreement in the first place, because the principal debt is 8 million. The claims that are being threatened on top of that all add up to 15 million. But one can see from the face of the documents that they're claims for loss of business opportunities and the like. So they're not straightforward debt claims. We have no idea how meritorious those claims would have been. And Vision is a company in distress. And so settling an $8 million debt for a $6 million payment day is a perfectly sensible commercial deal for Sharp Trend to make. There's nothing inherently suspicious about that arrangement at all. Then there are, finally, in relation to Villa 3K3, three further new points. First, it said that the sale contract required the deposit to be paid, which was contrary to the account that was provided in relation to Al Noor. I've shown Your Excellency the contract, and that in fact it doesn't record that at all. The sale price is to be paid under clause 1 and then repaid upon settlement in exchange for the full payment of the sale price. So that's a bad point. Second, it's suggested that Mrs. Gupta should have given notice of the settlement agreement under the English Chabra order or the DIF-CO. That's in in my own friend's skeleton argument, page 28. We say that is just wrong because on whatever view one might take of the freezing order, it does not require notice to be given when properties are being marketed for sale. It requires notice to be given before a dealing in property. An agreement to enter into to market a property for sale is not a disposition in property. So we say that's plainly wrong. And then the third set of new points are taken about Al Noor, which is the legal consultancy which was acting for Sharp Trend. Now this is quite important because this is the basis for the rebirth of my learned friend's legal expenses application, which I'll come on to, which I say is really just an attempt, or the beginnings of an attempt by Trafigura to come between Mrs. Gupta and her lawyers. Now, the suggestion is, as it was put yesterday, that Al Noor is associated somehow with Mrs. Gupta's litigation funder, Nomas. Now, the first point I take about this is it is a new issue raised by new documents put into the bundle after Trafigura's reply evidence, and it simply ignores the Chief Justice's order that indicated specifically that there should be no new issues or new matters raised by way of reply evidence, much less by the addition of further documents thereafter. Trafigura have been aware of Nomas's involvement for some time. The documents that have been produced date from 2025. So this is not new information. It could have been pursued in Trafigura's original application, and if it had been, there would have been an opportunity for Mrs. Gupta to respond to it. But in any case, the documents that have been produced do not begin to justify the inferences that are invited from them. Now, there are two things said. First, it's said that Al Noor is not a debt collection agent at all. But Your Excellency, it's no secret that Al Noor is a legal consultancy. It is in its own name. We see that in Mrs. Gupta's first witness statement on this topic, C6, page 770, at paragraph 11. We don't need to turn it up, but I'll read it out. Sharp Trend engaged a debt recovery agency called Al Noor Legal Consultants. So that is a bad point. It's a bit like saying that Reed Smith is not a law firm because it's involved in asset recovery in the present action. Straightforwardly, I mean, it's obvious that law firms assist in asset recovery. It doesn't mean that there's anything wrong with the way that Mrs. Gupta referred to them. The second point is that Al Noor is said to be commercially associated with NOMAS, Mrs. Gupta's litigation funder. It's not quite clear what the term commercially associated means. I take it to imply, although not actually to say, that the money paid to Al Noor when it was representing Sharp Trend somehow made its way back over to NOMAS in order to be used for the Gupta's benefit. But there's just no basis for that inference at all, even putting to one side the contemporaneous documents evidencing the transactions with Sharp Trend. What the documents actually show is that Diginex, a NASDAQ-listed technology company, has reached agreements separately with Al Noor, a legal consultancy, and NOMAS, which is involved in litigation funding, to assist it with operations in the UAE. And that is, with respect to my learned friend, entirely unsurprising. There is nothing at all surprising about a legal consultancy and a fund dealing with the same common client in the jurisdiction where they operate. Now, the document is, the MOU is at T17963. And we see it explains in the recitals what this is all about. A, Diginex is a NASDAQ-listed entity. It's a technology firm. B, Al Noor is a registered legal and consulting firm, has strategic partnerships with other professional services firms. C, Diginex seeks to expand strategically through a listing in the Abu Dhabi Stock Exchange. And Al Noor is willing to assist it with services in that regard. There's absolutely nothing surprising about that. The same thing with the document at T27971, which is an SEC report. And all that this records is that there are two agreements entered into. There's the one between Diginex and Al Noor, which we've just seen. And then there's a separate one between Diginex and NOMAS. So there's no contractual relationship, as far as we can tell, between NOMAS and Al Noor. Certainly no funds flowing between them, directly or indirectly. They're both providing services to Diginex for a fee. Now, Al Noor is a legal consultancy. My learned friend says, oh, NOMAS is not generally involved in the business of litigation funding. Not sure what the evidence is for that. But in any case, even if it's a fund more generally or involved in other operations, we just don't know what the nature of the services are because we don't have that MOU. There's just no evidence to suggest that somehow they're associated in some way that means that Mrs. Gupta's legal funding can be impugned or that the Sharp Trend transaction can be impugned. So that's Villa K3. The Discovery Gardens apartments. I'll just take this quite quickly because of the time. The short point here is notice was given in relation to two of the three properties. Mrs. Gupta believes that notice was given in relation to the third. She can't now find it. She's been through several sets of solicitors. If notice was not given, there's no reason to think that that was a deliberate attempt to flout the order. Your Excellency has seen that Mrs. Gupta has given many notices in relation to proposed dealings, including sales that did not actually transpire. And this property that was sold, flat 210, is one of the least valuable out of all of them. It's more valuable than the other two Discovery Gardens apartments, but it's less valuable by a significant margin than the Platinum Towers units or certainly Villa K3, which is a much, much more valuable property. So there's no reason why Mrs. Gupta would be trying to sneak that one out when she's been playing by the book in relation to the rest of the properties. So that's all I have to say about dissipation and justice and convenience. So I say that really all of that taken together just shows that the current undertakings, perhaps if they made fractionally clearer, are otherwise working perfectly well. And if Trafigura has not taken action to protect itself, that's not because Mrs. Gupta has been, as my learned friend puts it, playing fast and loose. And it is important to remember that that is a regime that was agreed in 2023 in order to balance the parties' interests between intrusiveness on Mrs. Gupta's commercial privacy and Vision's ability to deal with its assets as against Trafigura's need to preserve assets. Now, can I deal briefly with onshore enforcement? Two short points here. First, we say that conduit jurisdiction is just not available for an interim order. I think I can take this fairly briefly. That all we need to do is to look at the new court law, which is in the bundle at Authorities Bundle 48, 1363. We can pick it up at page 1378. We see that Article 29, of course, Your Excellency will be very familiar with these articles by now. Article 29 provides for the DIFC enforcement judge. Article 30 defines what an enforcement writ is, which of course includes, it's very broad, includes all decisions and orders. Article 31 is then concerned with internal or inbound enforcement by the DIFC court of foreign orders. So that allows the DIFC court to enforce foreign arbitral awards, awards of judgments and judicial decisions of foreign or local courts, including the Dubai courts. And critically, at paragraph 4, we see that it includes expressly interim and precautionary orders and decisions issued by local or foreign courts, including the Dubai courts. And so the DIFC on inbound enforcement is authorized, the DIFC enforcement judge is authorized to give effect to precautionary orders, interim and precautionary orders. And that's sensible, obviously. It allows the DIFC as an international hub to receive interim freezing orders made in other common law jurisdictions around the world, so that one can come to the DIFC with an English freezing order and have it recognised. And of course, as Your Excellency noted in the Court of Appeal, that's not necessary. You still have the power under 15.4 to grant fresh interim relief, but this is another way to the same outcome. But I contrast that with Article 32. Article 32 is about outbound enforcement onto the onshore courts. And we see that applies to enforcement writs, which is broadly defined, but then those enforcement writs have to pass certain criteria to be amenable to the conduit jurisdiction into the onshore courts. And the first of those criteria is that it must be final and executory. And the short point we say is that a freezing order is just fundamentally not a final and executory order. It is an interim order. Lots of authority to that effect. So I've cited some of the cases in my skeleton argument. Now, that scheme is consistent broadly with the old judicial authority law in some respects. We see that at page 1359 of the authorities bundle, which is at tab 47. But it's also different. It's interesting the way that it's different. Article 7 provides for the execution. And there's two pairs of sub-articles. So sub-article 2 and 3 are concerned with outbound enforcement. And we see that in 2A, there's the requirement that it's final, that the judgment, decision, or order, or ratified arbitral award, now compendiously defined in the new Act as an enforcement writ, is final and executory. So the same threshold requirement applied under the JAL. But interestingly, under sub-article 4, which concerns inbound enforcement into the DIFC, under the JAL, there was a similar requirement that the judgment, order, or decision had to be final and executory. And what's happened in the new court law is that that has been loosened. And so now the DIFC, as an international commercial hub, has the power to just receive foreign freezing orders, entirely sensible and commercial. But what has not changed is that one cannot just take interim orders made in the DIFC onshore through this conduit mechanism. And that's entirely understandable because, of course, they're just different types of relief in a civil law system onshore. You won't have, with an attachment order in onshore Dubai, things like the Angel Bell exceptions, reasonable living expenses, and so on. So it's entirely understandable why that distinction may have been made. So we say that fundamentally onshore enforcement is just not available. Now, what consequence does that have? It, of course, doesn't prevent Your Excellency from making a freezing order, but it does have implications for how it is used. And I would say that consequential orders would need to be made in order to ensure that Your Excellency's order, if one is made, is not misused in the same way that Sir Jeremy Cook's order was. Now, that's the first point. I should say also, there's nothing in Your Excellency's decision in the Court of Appeal which changes that. I was proposing to go through that in some detail, but I just don't have the time. The key point is that that decision was all about the power under Article 15.4. And there was some argument about conduit jurisdiction, but ultimately there was no decision reached about the nature of that jurisdiction.
About the jurisdiction and powers of this court.
Yes, that's right. And there's a reference in my skeleton argument to Justice Sir Jeremy Cook in Jones and Jones. I won't turn that up now either, but effectively the decision there was made, well, I'll grant the injunction here now. You can go off to Dubai and see if you can get precautionary attachments there, and then come back and we'll see what happens to the DIFC order. That's the first point about onshore enforcement. The second point is not about the statutory conduit enforcement mechanism, but is about the use of freezing orders outside the jurisdiction generally. And this applies regardless of whether the order is being taken onshore or somewhere else in the world. And as I mentioned before, the standard form freezing order has the conventional undertaking that the claimant won't seek to enforce it outside the DIFC. Now, in deciding whether it's appropriate to remove or modify that standard undertaking, the English courts have developed very well-known guidelines known as the Dadorian guidelines, with which applicants are expected to comply in seeking any such permission. Perhaps we just turned that up. It's in Authorities Bundle 18379. The guidelines are listed on page 382 by the Court of Appeal. So there's a few that are relevant to this case. Guideline 1, it must not be oppressive, the enforcement abroad. Guideline 2, consideration should be given to granting relief on terms. Guideline 4, permission should not normally be given in terms that would enable the applicant to obtain relief in the foreign proceeding, which is superior to the relief given by the freezing order locally. And guideline 5, such an application as that now brought by Trafigura would ordinarily need to be supported by expert evidence. Now, the one that I particularly want to underline in relation to this is guideline 2. If we go over to page 384, particular passage which is relevant for us is under the heading guideline 2 at letter D, at paragraph 32. We say that Lady Justice Arden says the discretion to grant permission is one to be exercised in the light of all the circumstances. Such options would undoubtedly include the option of granting permission on terms, that is, permission to enforce outside the jurisdiction on terms, for example, by stipulating the type of actions that are to be commenced abroad, the number of actions that may be brought with the court permission, and requiring the claimant in appropriate circumstances to report back to the court. Now, what I say is that if Your Excellency, contrary to everything I've said, is minded to grant injunctive relief, and if, despite no attempt having been made to grapple with these guidelines, Your Excellency is prepared to relieve my learned friends of the usual undertaking, and my starting position is that none of that is appropriate, then granting permission on terms such as this is really essential in this case, given the way things have unfolded to date. And those terms, I say, should require two things. They should require, first, that Trafigura actually take the routes which it has said it is going to take by commencing an action in simulation or an indirect action, and by doing that in short order. And that if those are dismissed, then the relief should lapse within a certain period thereafter. I don't say it should lapse immediately. They should have a window in which to come back to apply again. But it shouldn't rest on Mrs. Gupta to have to come back to this court to be relieved if the enforcement routes which Trafigura says they're going to take are either not taken or they're taken unsuccessfully. That's the first point. Second is that the terms are also to require that Trafigura does not take any other route, including to obtain superior relief or leveraging Your Excellency's order for the purposes of execution. So they shouldn't be relying on any injunction that Your Excellency grants as establishing any particular fact. They shouldn't be pursuing other enforcement actions, arrest warrants, and so on. And they should be withdrawing attachments against Mrs. Gupta in the nature of $625 million. All of that should come to an end. So that brings me to the end of the variation application, and I now need to deal with the legal fees application. Now, this application is quite a serious application. It's been bolted on to the end of my learned friend's skeleton argument on the basis, I think, of the new documents in relation to NOMAS. Now, the order that my learned friend is seeking is very wide-ranging. No draft of it has been provided, but we see the terms of it in his skeleton argument at page 42. At paragraph 87. So first of all, he wants a copy of the funding agreement pursuant to which Mrs. Gupta says she's receiving her legal fees. And then he wants an affidavit. We see over the page what that's meant to set out. All of the amounts spent, both by Mr. Gupta and Mrs. Gupta in the proceedings, the date on which NOMAS commenced providing funding, full particulars of the payments which have been made. And that includes, but is not limited to, the date and the amount of the payment. So every payment that's been made, how much and when, the identity of the payor and payee, together with details of their bank accounts. So we're going to have an affidavit with the bank accounts of all of the lawyers, including any payment that was routed by a series of payees, payors and payees, the identity of all of them, and all of their bank accounts. This is just extraordinary relief. And it is the beginnings, transparently, of an attempt to intermeddle with Mrs. Gupta's ability to obtain legal representation. Now, the basis on which my learned friend seeks this just muddles in various different powers, which all have different purposes. Now, there is, of course, a power to grant ancillary disclosure in order to make a freezing order effective. But it's impossible to see how this is even designed to make the current freezing order that they have effective. It just doesn't make sense at all. Then he relies secondly on RDC 25.17. That's the power to provide information about assets which are or may be subject to the freezing order. The rule's not quoted in the skeleton, but the power is specifically to provide information about relevant property or assets which may be subject to an application for a freezing order. Now, this order that they're seeking doesn't do anything of that kind. There's no suggestion that there'd be an entitlement to a freezing order over funds that have already been paid to lawyers. No basis for that has been articulated. And then third, it said, well, there's a power to disclose the source of legal fees if there's a basis for showing that the funds are coming from frozen funds. Now, my first response to that is there is no such basis. I've taken Your Excellency through the documents about NOMAS and Al-Noor, and that's all just assertion. No basis at all to suspect that that money is coming from frozen funds. But in any event, that's just not what this order is doing, because it's not asking for information about where the funds came from. It's asking for information about where they went. So he wants the agreement, presumably because he doesn't believe what's being said about NOMAS providing funding. There's no basis for that because Mr. Fedrigoli, an officer of this court, has confirmed it in an email. Mrs. Gupta has confirmed it in a witness statement. So there's no basis for doubting that that is the case. But then 87.2 is not even concerned with identifying the source of funding. It's trying to find out how much has been paid to whom, when, bank details of the lawyers, and so on and so forth. We've seen the hostile strategy that Trafigura has adopted in this litigation. Your Excellency should be under no illusion that this is an attempt to intermeddle with her legal representation. Entirely inappropriate, no basis for it, and should be dismissed out of hand. Excellency, I think that brings me at last to the end with 5 minutes to spare.
Indeed. Thank you, Mr. Trotter. Yes, Mr. Peters.
Your Excellency, I propose to reply. I will keep it as brief as I can, and I will proceed in approximately the same order as we did in opening. So I will start with this question of whether we need to establish our entitlement to Chabra relief afresh at this hearing. Now, given how the argument has unfolded, we say that the answer to that question actually turns on another question, which is the variation application seeking a variation of an existing interim injunction, or is it seeking a substantively new and different form of relief? Because if it is the former, then we absolutely should not have to revisit the question of our substantive entitlement to the original relief. I think I'd have to accept that if it were the latter, there might be a lot more force in the point having to be reconsidered. So perhaps the most important thing to ask about the provisions of Schedule D to the Court of Appeal's order is, do they provide for Chabra relief? Is that what they do? And we say the answer to that is clearly yes. And it's perhaps worth having Schedule D up. It's Bundle A, tab 13, page 191. And in opening, I said that these provisions, which go over the page, contained a regime which, if operated in accordance with its terms, was functionally equivalent to, and in some ways actually more restrictive than, a standard form freezing order subject to the standard form exceptions. And that point has not been rebutted, and that's unsurprising because it's clearly right. What we have is an order that places very significant restrictions on freedom to deal with assets by a person, namely Mrs. Gupta, who is not herself directly liable to Trafigura, on the basis that the assets to which it refers might be available for the purposes of enforcing a judgment which Trafigura has obtained against someone else, namely Mr. Gupta. That is the definition of Chabra relief. Indeed, if it really is Mrs. Gupta's position that Schedule D does not set out a form of Chabra relief, then one asks, what does she say it is? And on what basis does she say that the court had power to grant the relevant order? It is only explicable as Chabra relief, and as I showed you in the opening, it was sought as Chabra relief. So the original order in Schedule D is one for Chabra relief, and the order we are now seeking is a varied form of the same type of relief. As I have explained, the practical effect of the relief that we are now seeking is to reverse where the burden lies in relation to applying to the court concerning dealings with relevant assets. Under the current regime, we need to apply to stop them. Under the new regime, Mrs. Gupta would need to apply to permit them. And that is why we say we absolutely don't need to start from scratch. And this is, in my submission, encapsulated rather elegantly by His Excellency Judge Cook at the without notice hearing before him in November. And if we could go to that briefly, it's Bundle D, tab 8, page 1260. And if we look at page 30, transcript page 32, which is in the bottom right-hand corner, at this point in the hearing, Mr. Macpherson was getting into his stride in explaining the jurisdictional basis for the urgent relief we were seeking, but His Excellency Justice Cook cut him off at the top, line 2. We don't need to go there, do we? We've got a Court of Appeal freezing order, and the question is whether events have happened which suggests that that ought to be varied in some way, at least on a temporary basis, until we can hear the full variation application. And we say that's absolutely right. And the fact that Justice Cook said that wasn't the result of any lack of fair presentation, because the judge had the Court of Appeal's order in front of him, and he could see what relief it provided for, and he understood what fresh relief was being sought, and he frankly appears to have considered it axiomatic that the latter was a variation of the former. He's clearly right about that. And what we say, therefore, is that the attempt to force us all to have an argument about substantive entitlement to Chabra relief from scratch is really an inappropriate collateral attack on the injunction granted by the Court of Appeal in circumstances where still there is no application to set aside or vary that order. And we say that's all relatively simple and straightforward, and that although it was attractively presented by Mr. Trotter, his submissions boil down to raking over what is an admittedly complicated procedural history, with the result of, frankly, missing the wood for the trees. Now, of course, then what is said is that whatever the position might actually be, that we aren't allowed to say what I've just said, because the point's been conceded, and I can deal with that, I hope, again, relatively briefly. even if you were to accept that there was a concession as to whether the issue of our entitlement to Chab relief had been determined by some other court, it's not clear to us that that would necessarily preclude us from advancing the submission I've just made, which relies on nothing more than the simple proposition that Schedule D to the Court of Appeal contains Chabra relief, and all we are doing is asking for a variation of that relief. In any event, the question of whether there is an abuse of process in us doing what we are doing requires a sort of broad overall merits-based assessment of the position. And we do say that where an abuse is said to flow from an alleged concession, the concession must be clear, unequivocal, and made in circumstances where it would be abusive to allow the concession to be resiled from.
Let's put the question of concession to one side for a moment.
Yes.
Let us suppose I come to the view that that the question of reason to suppose in relation to the assets, the subject of the freezing order, was never addressed in the when the ex parte order was made, because that was dealt with on a basis of jurisdiction, and it was not addressed in the Court of Appeal because the question was one of jurisdiction. If I were to come to the conclusion that the criterion for the grant of Chabra relief had not been substantively addressed by any court, would it be open to me then to say, well, as a matter of fairness and justice, it should be dealt with now?
No. And the reason I say that, the reason I say no, is because we've focused, understandably, on the language of the issue being determined. It might actually be better to use the language of the issue being resolved, which may seem like dancing on the head of a pin, but the reason I say that is that there are two ways an issue may be resolved in an adversarial system. The first is it being determined by the court. The second is by a party.
I'm going a step back.
Yes.
The question I'm asking, was it considered?
Well, what I was going to say is the other way the issue may be resolved is by a party having an opportunity to take a point, not taking it, and the world moving on, such that it would be inappropriate for them to take it later. And my point is, when you get to it's the point I made in opening, when you get to the inter partes stage of an injunction, if you want to say the injunction shouldn't be granted, you should say why. And if you want to apply to discharge it on the return date or at a certain period thereafter, then you do that and you bring forward your grounds on which you say the order shouldn't have been granted. But if you don't do that, you don't successfully reserve your position to re-argue the point whenever you may please later in the proceedings, because the point is closed. And so that is why, as I say, it's a key feature of an adversarial system. The court only considers the points that are properly raised before it. And so if a court ends up not considering a point because a party hasn't taken it when they should have done, that's an end of it. And if you think about it, if the position were otherwise, the management of proceedings where interim injunctions have been granted would become chaos, frankly, because every time somebody came back, even for a trivial amendment of an interim injunction, say, that could be said to provide an opportunity for the person subject to that injunction to raise any point in relation to the merits of it.
This
regardless
is known in the law as a floodgates argument, I think.
Well, it's a bit like that, but I only resist that slightly because that's normally something explained as a matter of a point put as it were to denigrate an argument. It is a sort of floodgates argument, but actually it's what are the rules of abuse of why is it that the rules of abuse of process don't only focus on points that have been decided, they focus on points that haven't been raised when they should have been, and it's for precisely this reason.
I'm not really looking at it through the prism of abuse of process. I think one doesn't necessarily have to get to that level to think about whether or not the case, having been fully argued before us, having not been fully argued anywhere else, and involving a substantial imposition on somebody's liberties, should be considered properly.
Well, I see that, and it's an entirely understandable instinct, but it is in my submission, in this particular type of case, an erroneous instinct, because there have been plenty of opportunities for the validity of the underlying injunction to have been addressed. And it does give rise, in my submission, to a somewhat extraordinary situation. Just obviously, I will say you shouldn't reach this decision. Say you were to refuse the variation application on the basis that you considered that the case for Chabra relief wasn't made out. Question, where would that leave the Court of Appeal order? You'd have a Court of Appeal order imposing Chabra relief, which has not been applied to be set aside, and which we would say can't be applied to be set aside at this stage. And then you'd have a judgment of this court saying that there was no basis for the relief that order contains. This would be a bizarre situation.
Having sat on the Court of Appeal, that.
But the point is, it's not a matter. It's very easy to focus principally on what the Court of Appeal, the Court of Appeal addressed, as in any court in a system like this will, the Court of Appeal addressed the arguments that were put to it. And the way interim injunctions work, if you want to object to them continuing pro tem, is you take your shot, and if you miss, you miss. And if you miss, you can't take another shot. So we say that actually it is very problematic. As I say, I think in some ways this debate I'm having, the reason I framed it the way I did, is that actually I suspect the real disagreement between the parties lies elsewhere, in that the basis on which Mrs. Gupta's submission seems to be advanced is that actually we are seeking a new and different order. We are seeking something. We're not just varying an existing injunction. We are seeking an entirely new, jurisdictionally and substantively new injunction. But the problem is that's just wrong on the interpretation of the relevant orders. Once you are in the territory of a variation to an existing order, the relevant question is, should the variation be granted? Not, was the existing order properly granted? That's what it boils down to. Now, Your Excellency, I was going to deal with the concession point because I have a little bit more to say about it. If it's not assisting you, I'll move on, but I think I should address it briefly.
Well, I think I understand where you are on that. You've canvassed the argument previously. The heat of the moment, comments made carelessly by judges and counsel.
Well, I think I was going to say I was going to say, because I wanted to come back on the way those submissions were attacked by Mr. Trotter. Obviously, although perhaps with a little bit of regret, I'm not arguing that there is some special rule that applies to counsel that allows us to speak incautiously. My point is that whether a concession is binding and whether it was clear enough is context specific. And my point is that a heat of the moment exchange between counsel and a judge at a hearing at which nothing substantive ends up being decided is particularly unfertile ground for a concession.
Well, I think I'll say to you, Mr. Peters, that ordinarily I would expect a concession to be formal as of record concession rather than by way of passing comment. Now, what use one makes of a judicial utterance in the course of argument or counsel's response to it in the course of argument may be debated. But ordinarily, I would think of a concession as something that has a formal and binding character.
And here, what we have, I don't think I need to go back to the transcript, but just to describe it briefly, actually, what Mr. Trotter did in his skeleton is he quoted the first half of a sentence from Mr. Macpherson, saying it wasn't decided, comma, and then referring to the position in England. So the whole thing is highly ambiguous. The passages that he took you to in our written evidence, the first was a comment by Mr. Lakin that the position in relation to the Schedule D assets hadn't been determined in England, which is both right and irrelevant. And a paragraph in which Mr. Lakin simply summarised what the requirements for Chabra relief are and summarised them accurately. And I do say, given what you just said, the fact that one has to sort of go digging through the transcript and digging through later documents to try and work out what the concession might be and whether it was made rather tells you that it wasn't. I was going to now move on to Chabra on the merits, on the basis that on the assumption that you're against me on my first point. On the facts, I want to start with one thing because it may be that it's important, which is that my learned friend says that Trafigura and Mr. Gupta had only been dealing with each other since 2019. And just so you know, and I don't criticize my learned friend because there's a lot of detail here, that's not quite right. 2019 is the point from which Mr. Gupta was on his own case defrauding Trafigura. They had been dealing with each other on substantial and increasing business since 2014, or perhaps 2015. There's a little bit of ambiguity about that. That's in Mr. Justice Saini's judgment in the English proceedings, which I don't need to go to. We start with the basic factual proposition, which is we do say the evidence suggests that Mr. Gupta was the one who had all the substantial business. And although Mr. Trotter's right about the transit finance nature of the dealing, the fact is that when the music stopped, Mr. Gupta had received a net $600 million from us, in return for which Mr. Gupta and his company, had received a net $600 million from us, in relation to which they had provided material worth at most, think about a couple of tens of millions of dollars, tops. And so the question is, where on earth has that money gone? And we do say, by comparison, it appears to be Mrs. Gupta who's holding certain of what one might have thought were the very substantial assets. So that has given rise to the issue of fact, as I say, in relation to which we only need an arguable case, which is, where has the value in Mrs. Gupta's assets come from? And we say, well, where did Vision get the money to acquire its interest in Silver Star, which it says it acquired for over 30 million? No credible answer. How did Mrs. Gupta acquire a minority stake in Hanji, said to be worth $158 million, when she then contributed it into Vision in 2018? Now, the only answer that Mr. Trotter provided on that is he said, well, the accountants tell you that the subsequent growth in the value of the shareholding in Hanji was not valid in terms of how it was calculated. Well, fair enough. But there's nothing to suggest that the original value, which was still 158 million, wasn't a true value. And how on earth did Mrs. Gupta fund that? We had the point about Vision. I mean, I took you through the accounts. You'll see what we say about Vision and what's going on with Vision. The big criticism we made about, well, a couple of criticisms we made about Vision. The first is we said, well, where did it fund, how did it fund the acquisition of properties? Now, I am not a forensic accounting expert, but I can read a set of accounts. And I do know that when a company acquires an asset, you get the asset reflected as a positive thing in one place, and there will inevitably be a countervailing entry somewhere else. Either its cash will go down, or shareholders' funds will go up because it's been provided by a shareholder. This is not forensic expert stuff. This is fairly basic commercial stuff. And my point was, on the accounts, they don't explain that. And as far as I'm aware, that isn't actually disputed. The biggest point, particularly on the 2019 accounts of Vision, is the absence of a bank account. And we do say that is astonishing. I mean, Mr. Trotter says, well, they weren't, because they were back-to-back trading, Vision was only receiving small amounts of money. Well, relatively small, but we're still talking about multiple millions of dollars. And I mean, he floated the possibility that maybe Vision was using Mrs. Gupta's bank account, but that wouldn't explain what the accounts say, which is not that Vision had cash at someone else's bank, but that Vision didn't have cash at the bank at all. So we do say that there remains this glaring unanswered question as to the source of Mrs. Gupta's assets. And just to be clear, it may be that that question is capable of an entirely innocent answer. I don't come here asking for final findings on anything. What we have is, what we say is actually a pretty typical Chabra type situation where someone has more assets than their various explanations as to their income and wealth can explain. Now it is said, well, husband and wife may share assets and there may be nothing wrong with that. And again, ultimately, if there were a trial about all of this, it is possible that the court would conclude that to the extent that Mrs. Gupta has received assets from Mr. Gupta, she's received them as gifts and there's nothing untoward and it's all fine. We would obviously in due course argue against that conclusion, but is there an arguable case that that is not so and that the position is as we allege it? Absolutely. Now I wanted to deal, and I can deal with it quite briefly, the position in relation to UAE law, because actually it still boils down to a couple of quite discrete points. I think the first thing that's important to say is you need to distinguish between the factual and the legal, because in any claim in the UAE on these causes of action, there would be a question actually of primary fact, which was, if I can put it colloquially, what was the deal between Mr. and Mrs. Gupta in circumstances where he seems to have moved lots of assets to her? And there are lots of possible answers to that and lots of arguable answers to that. One that I floated, the worst for us, would be that it was just an ordinary sharing of assets between husband and wife. Another would be a so-called gentleman's agreement, to adopt Your Excellency's phrase. But the other would be something more specific along the lines of Mr. Gupta wanting to put some assets, and perhaps assets of very substantial value, beyond the reach of his creditors whilst retaining control of them and retaining, in fact, rights over them. But I accept I am not in a position to advance a case that that is so other than by inference. And I've set out the primary facts, and we've set out in our evidence the primary facts from which such inferences can, at least arguably, be drawn. And what we say is, if you do get to a position where Mrs. Gupta is acting as Mr. Gupta's nominee, then the gates in the UAE are at least arguably open for the reasons that I've given. Now, I don't know how far Mr. Trotter was pushing the submission, but let me put it this way. If it was shown that one person had agreed with another, orally, not in writing, to keep their assets with that person to avoid the claims of their creditors, I'm not sure it could seriously be suggested that UAE, and not against a specific creditor, but against creditors generally, including future creditors. Could it be said that UAE law wouldn't work, that UAE law would be confounded by that fact pattern? Because there wouldn't be any writing, so the evidential requirement that Mr. Trotter relies on would be a problem. And the only way around that would be fraud or circumvention of the law directed at a particular person, and because the agreement was anterior and too general, that no individual creditor could complain about it. We do say that it would be surprising if that were the position under UAE law, and we do say that there's actually nothing in any of the material he cited that necessarily justifies that. It is right. We do say there appears to be differences of view as to the strictness with which the requirement for proof in writing falls to be applied, and that the rules about fraud or circumvention of the law are invocable by a person who is the target of the conduct. Now, that begs another question that you can't possibly resolve on an application such as this, which is how precisely does the target have to be drawn? Does that only apply if transactions are targeted at a particular person? Or does it apply if there is a more general arrangement to squirrel assets away from creditors as a class? We would say it would be rather odd if it wasn't the latter, because that would create an enormous lacuna in UAE law, which, as Mr. Trotter rightly pointed out, is in some ways even stricter about these sorts of things than some common law systems. So we do say that the UAE law rules, that the UAE law routes are potentially open. Whether they will actually work will depend on potentially some quite precise nuances as to what the factual position is found to have been as between Mr. and Mrs. Gupta. So, Your Excellency, we say on the facts, the position is very much as we've always described it. And we say on the law, we accept the position is uncertain, but we do say that it's certainly not a situation in which the court could conclude with the certainty that it would have to, that the UAE legal routes don't work. Now, my next subheading is the appropriateness of the proposed variations. And I want to start with breaches of previous orders, and particularly Villa KO3. And this is one point on which a little bit more detail is, I'm afraid, going to be, I think, useful. Now, Mr. Trotter started with the Platinum Tower notice, which is Bundle K, tab 29, page 2145. Now,
yes, I have it.
Yes. Now, what is said just below the listing of the properties are being sold towards settlement of an old trade debt of Vision Investments Limited incurred before the WFO and Chambra, thus for a commercial purpose. Now, Mr. Trotter seemed to think this was helpful to him. I'm not quite sure why, because the one thing it shows is that Mrs. Gupta was absolutely able to give her lawyers clear instructions to give a notification in that form. If the purpose of a dealing was payment of Vision's creditors, she was absolutely able to say that clearly and unequivocally. Now, that begs a threshold question in relation to the Villa K3 notice, which is why on earth, which by the way is served some 2 months later, why on earth didn't she say the same in that notice if, in fact, as she now says, that the sale of Villa KO3 was in fact an alternative to the sale of the Platinum Tower units? We'll come to that notice itself in a moment, but if she's being upfront with Trafigura as to what's going on, why didn't she do that? And of course, there is an obvious answer, which is that if she'd said that, then the next question would have been, well, why are you paying Vision's debts? And that is something I'll come back to in a moment. But if we go to the Villa K3 notice itself, which is K372161, now, Mr. Trotter made a valiant attempt to explain why this notice wasn't demonstrably untrue. But the problem is, it's only not demonstrably untrue if you just ignore bits of it. So, for example, a bit that Mr. Trotter rather skipped over in his submissions, Mrs. Gupta further confirms that the proceeds of sale will be applied in accordance with Clause 2 of Schedule C, including to meet ordinary living expenses and reasonable legal costs.
I'm so sorry, Mr. Peters. it gave a reference K37. I'm not sure
sorry,
that's
if I
right.
given the misreference, I apologise. You give me 1 second. Letter from Larson to SH London, 26th of October, 2161. I've got it at K37. Page 2161.
I think it's K23.
Oh, I do. Oh, yes, sorry. I've got a version of the index which now has some entries missing. I can't get a break on this one, but anyway, sorry. Do people now have the? Thank you to Mr. Macpherson. Do people now have the document?
Yes, thank you.
My point is, she was saying that the money would be used, amongst other things, to meet legal and living expenses, which she must have known wasn't the case on her evidence. So how on earth could she possibly have honestly instructed Larson to say that? The phraseology of maintaining or operating the excluded assets is in fact untrue, because the excluded assets are the particular vision properties. It's a defined term in Schedule D, and it's capitalized in that letter. So that is in fact wrong. I think Mr. Trotter's point is it's a sort of it's an innocent mistake rather than anything more sinister. It is wrong. It also does beg the question I've already raised, which is if she's being straightforward rather than evasive, why use that form of words rather than the form of words that she had used 2 months previously in relation to the Platinum Towers notice? So we do say that the notification in relation to Villa K03 is obviously in breach of the notification requirements. And that's before you get to the complete lack of particularity, which is what I think particularly irked His Excellency Justice Cook when he saw it. Because his point, which we say is a good one, is where you have these notification requirements, simply producing a notice that effectively says, we confirm we are going to use the money in accordance with the requirements of the order, isn't good enough. Whatever reasonable particulars mean, they don't mean parroting back effectively the language of the order in a way that isn't of any use to anybody. And we do still rely on the breaches in relation to the Discovery Gardens unit and in particular the Cook order. Now, one of the things that Mr. Trotter said about this is he said, no, and I might come back to this, he said that the notification regime is working fine because there are instances of notices having been given and not having caused controversy. But that is a non sequitur. What we made this application when we did because we were concerned the notification provisions weren't working, and the saga in relation to Villa K03 proves that we're right. On breach of the orders, you have my points on the commerciality of Mrs. Gupta's guarantee and of the settlement agreement. I mean, Mr. Trotter observed that it makes perfect sense for her to put herself on the hook. I should say that is, whilst that might seem superficially attractive, it doesn't make a great deal of sense in circumstances where it's her own position that the shares in Vision were worthless, and she did not have the money to pay that debt without rendering herself homeless. Also, Mr. Trotter made the point that Sharp Trend might have been willing to settle because there were speculative elements to its claim. But one of the features of the various agreements you've seen is that they actually acknowledge and fix the liability at the $15.6 million. So we do say that there have been a series of serious breaches of the orders, most strikingly in relation to Villa K3, and that those show that the notification regime isn't working. And by the way, if you're with me, that notices have been filed which contain false information, that does fundamentally strike at the viability of any notification regime, because even if you could come up with a very convoluted, and it would have to be very convoluted, regime that covered sufficient particulars of every conceivable transaction that might happen, if you've got someone who isn't being straight with you, it doesn't matter. So now I want to move on to balance of prejudice. Firstly, prejudice to us. And I think the main point on this is the one I've addressed, which is the suggestion that the notification regime is working. And of course, as I say, just because there are examples of it having worked doesn't mean that as we sit here now, we can conclude that it is working. If it turns out, if you find, as I say, that a very substantial asset has been dissipated in breach of the order on the basis of a false notice, that tells you all you need to know in relation to the regime not working. But now I want to look at the other side of the coin, which is prejudice to Mrs. Gupta. And what is said is that the order will lock up all her assets and that will be highly prejudicial to her. Well, it will lock up Villa K1, but that has been frozen since 2023. And there's never been any suggestion that Mrs. Gupta requires to liquidate that property, which is in any event her home. The other asset of hers that is being locked up, to use Mr. Trotter's phrase, are the shares in Vision, which are said by her to be worthless. What you do have is a situation where Mrs. Gupta has been paying legal and living expenses since 2023 without any apparent difficulty. Then in the same vein, there's an allegation of prejudice to Vision. So Vision is not a trading entity. And so the idea that it needs, because that is one of the things you need to be careful of with a freezing order, which is that if you make a freezing order against a trading entity and it doesn't have appropriate restrictions, you stop it trading. But that's not the situation here. What is being said is that you're locking up its assets so it can't pay its creditors. Well, a similar point arises in relation to Vision. The Schedule D assets have been subject to restrictions for a very long time. They've been subject to the English restrictions since 2023. And in all that time, the only time it has been suggested that it needed to, well, there's only been one occasion on which it is suggested that it needed to liquidate assets to pay a debt, and that is in relation to the sharp trend debt, in relation to which there are reasons for profound suspicion which I've identified. And in the end, that debt was paid by a liquidation carried out not in accordance with the terms of the relevant relief. Of course, the other thing that's quite interesting about that one example is that that one example wasn't, in the end, an instance of Vision having to sell a property to pay one of its debts. It was an example of Mrs. Gupta selling one of her properties to pay one of its debts. So we say that the prejudice is overstated. And given the need to protect us from conduct of which we have already been the victim, it is justifiable in the circumstances. So the next issue on discretion I want to deal with is and the overall balancing exercise is our conduct and the criticisms of our conduct. Now, the submission is maintained that we do not intend to bring the various UAE actions we've identified as possible against Mr. Gupta. And Mr. Trotter's point is we could have gone earlier because we don't need a judgment recognized in the UAE in order to be a creditor. Well, even if that is technically correct, it is a wholly unrealistic submission, because I'm not quite sure what Mr. Trotter is proposing. He seems to be suggesting that what Trafigura should have done would be to take steps to establish its status as a creditor of Mr. Gupta's in the UAE on its merits. In other words, litigate in the UAE its various claims against Mr. Gupta, which include damages for claims unknown to UAE law, in parallel with doing the same thing in London, and that we should be criticised for not doing that. We say that is, as I say, that's unrealistic. The obvious thing for us to do is establish liability in the primary jurisdiction, London, and then obtain recognition of the London judgment in the UAE, because at that point our status as a creditor will be uncontestable. Now, in relation to this, he says that there's what we're trying instead is, I think the term is jurisdictional arbitrage. In practice, what he seems to be suggesting is that we will get an interim attachment and then be able to auction Vision's assets or Mrs. Gupta's assets to pay liabilities which aren't liabilities of Vision or Mrs. Gupta. And we don't understand that. We don't see how that isn't our intention, and we don't see how that would be possible. In relation to the onshore steps we have taken, the first thing, I've had some messages about this, is apparently there are some translation issues with the documents to which Mr. Trotter took you. I say that on instructions. I have to accept I don't have a sort of evidence on this, but my instructions are that, for example, the use of the phrase judgment debtor is a translation of what in Arabic is perhaps closer to person who is the respondent to this enforcement action. Now, I think I accept, in fairness to Mr. Trotter, that the language of respondent is used elsewhere in the same documents. But as I say, my instructions are that there are translation issues with these documents. And it just means that one has to be careful to look at the substance. And in particular, what I would say is one has to look at the substance of what orders have we actually obtained onshore. Because Mr. Trotter can say, well, they're being over-aggressive onshore. They're asking for orders they shouldn't get. But if he wants to make a submission about prejudice, what matters is what orders have we actually obtained. And as I understand it, the orders we have actually obtained are not offensive at all. They are simply provisional attachments on assets which have been frozen by the Court of Appeal's order, and frozen to a greater extent by His Excellency Judge Cook's order. I should say on the arrest warrant, that was sought at a time when Mrs. Gupta was, we say, still in contempt of His Excellency's Judge Cook's order, because she had provided by that stage some of the information that he had asked her to provide, but not all of it, and she hadn't provided the documents that she'd been ordered to provide. And so we say that it's not out of court to take steps to force her to comply with the court's order in circumstances where she hasn't. As it turns out, our application for an arrest warrant was refused. And that feeds into a broader point, links back to what I said earlier, which is you do have to focus on what relief we actually get in the onshore courts. A couple of more technical points on our conduct and onshore enforcement. Mr. Trotter took you to Article 32, I think, of the new court law. So it's worth just quickly looking at it. It's authorities bundle. I think it's tab 48 at page 1380, I think.
Yes.
And this is enforcement by the Dubai courts. And he relied on this, but we struggle with this a bit, because what this is doing is saying what the enforcement judge of this court shall be required to do in certain circumstances. It's a provision requiring enforcement judges of this court to seek assistance from the onshore courts in the circumstances identified. Well, okay, if you're not within the provisions of Article 32, then that obligation on the enforcement judge of this court might not arise. But it doesn't tell you anything about what local law says. The UAE courts, if asked to enforce, if a party comes before the UAE courts asking for an order to be enforced, then the UAE courts will apply their own domestic law, and they will either be prepared to enforce the order or they won't. The other point I want to make more generally about enforcement on shore is that Mr. Trotter spent quite a lot of time taking you through the cases that deal with the Dodurian guidelines and the general principles governing enforcement of orders in other jurisdictions. But the problem is that that misses the context of this case. This case was presented from the very outset as one where we were getting an order from the DIFC absolutely with the intention of enforcing it on shore. And that is why the orders which the court has actually made and which are not challenged on this application don't contain the standard form undertaking not to enforce elsewhere. They contain a modified form of that undertaking. And to give you an example of that, perhaps the Court of Appeal's freezing order, which is A13. And if we could go to 188.
Yeah.
So right at the bottom, you'll see the applicants will not, without the permission of the court, use any information obtained as a result of this order for the purpose of any civil or criminal proceedings, even the DIFC, other than for this claim, commencing or pursuing proceedings, and you'll see there below. And then 7, the applicants will not, without the permission of the court, seek to enforce this order in any country outside the UAE. Now that's, as I say, that's not something that was sort of sneakily put into the order without anybody being told. Right from the initial without notice application to Deputy Chief Justice Al-Madani, the application was squarely put on the basis that we did want to enforce the order that we were obtaining on shore. Now, that's what I was going to say about the variation application. If I could turn to the discharge application.
I've just been told to discharge the HR responsibility, that it's the transcriber break moment. That's convenient.
It's good that someone else has done it, so I'm grateful to Mr.
How much longer, Mr. Peters, do you estimate?
I reckon I will probably be another no more than half an hour, and probably less.
All right, well, we'll break for 15 minutes. Thank you.
So sorry, I didn't realize my camera was still off. My apologies.
Oh, I think it's there's a margin for error. Yes, Mr. Peters.
Your Excellency, I was going to deal now with the discharge application. I want to start with a procedural point, which just goes to where it fits into the overall landscape that you're dealing with. There is a somewhat unusual feature of this case. It is not one in which we obtain an ex parte order from His Excellency Justice Cook and are now seeking continuation of that order at an inter partes return date. We are seeking an order on our variation application, which is and has always been an inter partes application, which was actually issued before the application to His Excellency Judge Cook. So we're not in that typical situation where we are seeking a grant, Mr. Trott is seeking a discharge, and we then, if he gets it, we seek a regrant. We're not actually asking the court to, even if the court were with him on his discharge application, we are not actually asking the court to regrant the Cook order. We are asking the court to make an order on our variation application. That means technically we're not actually in the territory of discharge and regrant at all. The submission instead on Mrs. Gupta's behalf would have to be that alleged non-disclosure in relation to application A can and should lead to a punitive refusal to grant application B, which would be a much more draconian thing for the court to do, even if discharge were appropriate, and for reasons I'll now go on to develop, it isn't. I want to start briefly with the legal principles. So the classic statements of what the duty entails say that you have to disclose everything relevant, but then also say that ultimately relevance is primarily a matter for the court rather than for the people presenting the without notice application. Now, the practical problem with that is that those two principles combined usually in practice mean that the duty itself is of extraordinary breadth. Because what it means is that potentially an applicant has to address everything that he or she thinks is relevant, and also anything else that he or she might, at the far reaches of their imagination, consider any other person think would be relevant. And what that means is that it will almost always be possible for a respondent to point to some, and perhaps lots, of breaches of the duty. Now, what that means is that the authorities have come to recognize that when you're talking about an application to discharge an ex parte order, what really matters is not whether there are breaches of the duty of full and frank disclosure, but whether there are breaches which justify a discharge. And so what that means is that really the focus shouldn't be on, can I identify lots and lots of breaches of the duty? Because frankly, you're often going to be able to do that. What you need to start with is, well, what did the court do at the ex parte stage? Why did it do what it did? And in light of that, can I identify breaches that actually have a serious chance of leading to a discharge of the order? Because frankly, if I can't do that, I'm wasting everybody's time. And so this is essentially where the Court of Appeal, the English Court of Appeal, ended up in the MEX Group case. And I think it is worth looking at that briefly. It's Authorities tab 45. Page, I want to go to page 1064 in the first instance. Sorry, 1063.
Yes.
And then starting towards the bottom of that page, you'll see the heading, the presentation on appeal. So 126, Lord Justice Coulson is very critical of the number of allegations of non-disclosure that were made in that case. And then at 127, he engages with the principle. He said, that is not a sensible or proportionate way to address this sort of allegation. It is almost always the position that, no matter how big the case or how complex the underlying issues, a defendant's case that the claimant to make full and frank disclosure at the ex parte hearing will stand or fall on no more than a handful of alleged failures. That is because if the big ticket allegations of failure are not established, or are established but found to be immaterial, then the less significant failures will not bridge the gap. It is the law of diminishing returns. In our view, this case is no different to others. And then, accordingly, those preparing this sort of attack in the future should ensure that they concentrate their efforts on alleged failures of disclosure which are clear-cut and obviously important. Quality, not quantity, should be the watchword. The failure to follow that course has happened both before the judge and again on appeal, means that there is a real risk that the best points become buried in an avalanche of trivia. I do not believe that the judge was best served by the presentation of the points in this way. Indeed, I consider that proper assistance to this court can only arrive on the third day of the appeal hearing, when Mr. Calthon put his submissions on full and frank disclosure into some semblance of order and importance. And then, if I could just finish with this case, if you could go up to page 1058. And I draw attention to paragraph 112, which is in the judgment of Lord Justice Males, to give you an idea of just how fed up the English court, at least, has got with what one might call a blunderbuss approach to full and frank disclosure. There, Lord Justice Males agrees and indicates, points out that this point has been made before and obviously not been properly received, and threatens that in future, if people seeking discharge of the order don't act with sufficient discipline, they can be expected to be sent away with a flea in their ear. And so we say the starting point is you've got to ask yourself, what was the hearing in front of His Excellency Justice Cook about? And why did he do what he did? Because that's what informs, ultimately, issues of materiality. So the situation is we had already made the variation application of which you are seized today. And we then made an urgent application on top of that because of and in response to the events of late October. And it was those events that were found that we considered, and His Excellency Justice Cook found justified, us running off to court and effectively preempting the inter partes hearing of the variation application and seeking interim relief pending that hearing. So, as Mr. Macpherson rightly pointed out, what really mattered were the events of late October, particularly the events from the 26th of October notification. And the focus of any allegations of breach of full and frank, if they're to have any real traction, and therefore be the proper points that you should be taking in line with the guidance in MEX, should focus on that part of the story. And that's reinforced if you actually go through, I'm not going to take you through it because it's late and you've seen it, the ruling of Justice Cook. In essence, there were two key points on which his decision was founded. The first was what he regarded as the obvious inadequacy of the 26th of October notice in relation to Villa K3. And on that point, as you've already rightly pointed out, he had the notice and he had the notification regime. And he was perfectly well able to, and did, read the one, read the other, and form his own view as to the inadequacy of the notice. And that didn't rest on dancing on the head of a pin as to precisely what was or wasn't required by the notification regime, and therefore didn't require extensive argument as to precisely where the limit of that regime was and what bare minimum compliance would look like. Because Justice Cook's plainly correct conclusion was that wherever the threshold was for compliance, Mrs. Gupta hadn't got anywhere near it. He characterized the notice as pretty much just a bare assertion of compliance, and he was right to do so. The second point that he thought was key was the position that Mrs. Gupta was adopting in relation to her obligations under the freezing order generally at that stage, which was to say, because of proceedings she'd filed on shore, she could just ignore it. And it is, we say, not surprising that Justice Cook was unimpressed with this court's orders being treated with that level of contempt, with a small c. So those were the key reasons we ran off to court, and those were the key reasons we got the order. And frankly, in relation to Full and Frank, nothing Mrs. Gupta has said lays a glove on us anywhere near any of those points. The closest she came in Mr. Trotter's submissions was to complain about the fact that we had criticised her asset disclosure and said that she had not disclosed a bank account with enough money in it, and that was a breach of the order, or might be a breach of the order. And I think Mr. Trotter's point was we should have known that that was a bad point, because we justified it by reference to her legal spend, and we should have known or thought it was possible that she was being funded. And we say that's not right at all. In fact, it requires us to have undertaken a rather elaborate and backwards set of hypotheses. So we did know that Mr. Gupta was being funded. But so what? The fact that he has funding doesn't mean that his wife does. What we did know, interestingly, is that at least at one point in the English proceedings, Mr. Gupta had been funded or claimed to be funded by Mrs. Gupta. So the only firm information we had about her funding was of her providing it to someone else, namely her husband. So we do say that overall, if you look at the core of what the hearing in front of Justice Cook was about and why it ended up the way it did, there are no allegations of material non-disclosure that have any traction at all. And in fact, interestingly, the vast majority of the complaints with which Mr. Trotter took quite some time are actually to be found not in the evidence that was specifically filed for the urgent application in front of Justice Cook, but in the evidence filed on this application. And that rather underlines, we say, the extent to which he has missed the relevant target. And so we do say that it's a situation in which we ran off to court urgently. As we've said before, we did so in relation to certain very specific events that we dealt with. Justice Cook thought rightly that those specific events provided a compelling case for the grant of interim relief, and so he granted interim relief. And everything else is, as I say, it's the wrong sort of exercise. It's fairly obviously an exercise in poring over the record to see if we could have taken more points against ourselves. And the answer is yes, we could have done. And that is the answer, as I've said, in any case of any reasonable complexity that anyone could choose to identify. So that's what I wanted to say about the discharge application. The final thing I want to deal with is the litigation funding disclosure application, which I can deal with, I hope, briefly. The suggestion seems to be that this is something of a sort of last-minute addition, and that's not quite right. This application is contained in our application notice for the variation application. It is right that it was put on the back burner. The reason for that is that we thought it was sensible. We were having a consequentials hearing in England, and in circumstances where Mr. and Mrs. Gupta claimed to be funded by the same entity, we thought it was sensible to get funding disclosure from Mr. Gupta first. I have to say, I suspect, if for no other reason than we thought there was a likelihood, or if not a reasonable chance, that there would be a single funding agreement governing both of them, given the obvious connection between the two sets of proceedings. So that's why it has been put on the back burner and then come back again. But there's nothing surprising or untoward about that. The basic point that underlines this remains: we cannot conceive of a situation in which any commercial funder would see it as worthwhile funding Mrs. Gupta's doubtless very considerable legal fees in these proceedings. It is mystifying when you think about it. She's not a claimant, so it's not a typical litigation funding scenario at all. And by her own admission, or on her own case, she claims to have very little in the way of assets. It's a very odd situation for a litigation funder to be involved. And in circumstances where it's the same litigation funder who appears to be providing equally uncommercial funding to her husband, and given the other points I've raised, we do say it is something that, in relation to which proper disclosure is appropriate, apart from anything else, to police the injunctions the court has already made. Now,
This is funding to meet her legal expenses. Now, there may be a number of motivations upon which one might speculate about that, but how does that engage with the question of protection of the asset position?
well, the question is this genuine commercial funding? Or is it a route for enabling monies to be made available for legal funding?
Yeah.
Coming from somewhere unknown to us. That's our ultimate concern.
Well, the question is, so what? Having regard to the principal relief that you're concerned about.
If, for example, and we don't know, I accept that I'm speculating, but then I have no option but to speculate, and it's legitimate speculation given what appears to be the uncommerciality of the arrangements. If there is money in a bank account somewhere that has not been disclosed, either by Mr. or Mrs. Gupta, and should have been, and that is the real source of legal expenses, and NOMAS has been interposed as a way of providing a veneer of legitimacy to that arrangement, that would be highly relevant, and absolutely disclosure would be justified. And that I make no bones about it, that is the thread at which we are pulling, and we're pulling at it not because we're desperate that Mrs. Gupta not have legal representation, but because we are genuinely mystified by these funding arrangements. Both for Mrs. Gupta and for Mr. Gupta. But obviously on this application, we are concerned with the position of Mrs. Gupta. So, Your Excellency, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Peters. Was there anything else, Mr. Trotter?
Your Excellency, we'd agreed that I'd have the right to come back on my discharge application because that's my application.
Yes.
I'd also like to say something about onshore enforcement because Mr. Peters has addressed that for the first time in reply. It's not addressed in his skeleton argument and was not addressed in his primary submissions either. So there's just a few brief points I'd like to make about that. I don't think I'll be very long.
Yes, very well.
On the discharge application, Your Excellency, it's striking, I say, that at the end of Mr. Peters' reply submissions, there was still no actual response to the substance of the complaints about full and frank disclosure that I elaborated on at length in my submissions. The only point of substance that was addressed was in relation to the point taken about Mrs. Gupta's asset disclosure. It was suggested that the only information that Trafigura had in relation to Mrs. Gupta's legal funding was that she was at some stage in the past history of the English proceedings providing funding to Mr. Gupta. Now, my submission that doesn't really scratch the surface of the complaint that we were making, which is that they were well aware that Mr. Gupta was receiving litigation funding for a long time. The allegation that was made before Sir Jeremy Cook was not even confined to Mrs. Gupta. It was alleged that both of them had lied on oath about their bank accounts because they were incurring legal fees in excess of $65,000. And that was obviously wrong on the material that Trafigura had. Now, beyond that, there were really just a series of technical points taken about full and frank disclosure. There was 3 of them. First, there was a new procedural point taken. It was said that the variation application was issued before the urgent application, so that this shouldn't be regarded as the return date of the urgent application. He then said that if Your Excellency takes full and frank disclosure into account, what that would involve is a punitive refusal by reason of a failure of full and frank disclosure on one application to grant relief on a different application. This was a clever submission, but in my submission it is just wrong, because what's happened here is that the inter partes application has been issued first in time. That really makes no difference, because there was then a short notice and or without notice application issued for substantially the same relief, which was granted. Then that order has expressly been continued only until this hearing. And so in substance, this hearing is the return date, because Trafigura has obtained the relief that it sought on the variation application on an urgent interim basis. And the question for Your Excellency at this hearing is whether that should now be discharged or whether it should be continued. So that procedural point is dancing on the head of the pin, I say. And the second point, he said, well, most of the points that are complained about were in Laken 2 rather than in Laken 3. I say that's both wrong and irrelevant. It's wrong because the points about which we complain are made very largely in both Laken 2 and Laken 3, and in the skeleton argument and on the transcript, and the references are all collected in Federal 1. I say it's irrelevant because Trafigura chose on its urgent application to put in a short witness statement adopting expressly parts of the previous evidence, and one can't just circumvent the duty of full and frank disclosure by saying, well, we didn't repeat the evidence, we just cross-referred. So again, that's a distinction without a difference. And then third, Your Excellency was taken to the MEX group case. And this, in my submission, is really the last refuge of an applicant who doesn't have an answer, because he says, well, we misled the court so much that you can't rely on any of it. Now, the short answer is we're just nowhere near that case, where even the transcript, the part that my learned friend took you to, illustrated that there was a trawl over various issues in a disorganized fashion over 3 days in the Court of Appeal. Our complaints have been dealt with succinctly as a subsidiary part of this hearing and encapsulated in an orderly way in Federal 1. So that's really all I have to say about the discharge application. I'm not sure that anything has really moved on. Now, in relation to onshore enforcement, Your Excellency will remember that there were 2 points that I made. First, about the statutory point, where the conduit enforcement is open for interim orders at all. The second was the Dorian point, about whether it's appropriate to permit enforcement of an order outside the jurisdiction, whether in Dubai or indeed anywhere in the world. Now, on the statutory point, I learned a friend made one argument about Article 32, to which Your Excellency was taken. That's at Authorities Bundle 48, 1380. And it was suggested that this article doesn't circumscribe the limits of the conduit jurisdiction. It just says, it just provides the duty of the DIFC enforcement judge, the circumstances in which assistance must be requested. But my submission, that's not really a tenable reading of this legislation, especially given where it comes from in the judicial authority law. But what it does is set out the scope of what is permitted to be enforced through that jurisdiction. And we see that clearly from the introductory words of the subparagraphs, where it says such enforcement shall be subject to the following conditions. And one of those conditions is that the order has to be final and executory, but others include the fact that there has to be an Arabic translation, the executory formula has to be affixed, there needs to be an official letter, and so on and so forth. What my little friend seems to be suggesting is all of this is just optional, and it only bites This article is only telling you the circumstances in which the enforcement judge must assist. Never mind any of these requirements. It would equally be open just to take orders through the conduit jurisdiction into the onshore courts without complying with any of these requirements. And in my submission, that's just obviously wrong. On the second point, the Dardorian point, there was strikingly no attempt at all to grapple with the guidelines in that case. It is, in my submission, very alarming, given the history of this matter, that my learned friend seeks, no doubt on instructions, to resist this court exercising any supervision over how its orders are used onshore. Your Excellency will remember that I took you to Guideline 2 in particular, which provides the Court of Appeal should consider granting any relief on terms, and other guidelines that make clear that the whole purpose of this regime is to avoid applicants obtaining interim orders from this court and taking them elsewhere, anywhere in the world, and obtaining superior relief. And there is obvious good reason for that, given the scope for things to get lost in translation, either literally, as seems to have occurred, or simply because of the difference in the functioning of legal systems. It's obvious that if you take a freezing order into a civil jurisdiction, consequences may follow which were not intended by the primary court. And then really the only answer to all of this was that he said to Your Excellency, well, the Court of Appeal order already includes a variation from the standard undertaking. He said, if we look at the annals of the annexes to that order, we see that it just restrains enforcement outside the UAE rather than outside the DAFC as the standard form. And this was effectively another gotcha submission. It's just another area where there was no argument, as far as I can see, about this question at all. At the ex parte stage, there was no attempt to justify to the judge why there ought to be permission to enforce outside the jurisdiction. That was never ventilated before the Court of Appeal, as it ought to have been done. My learned friend says, oh, well, that ship has now sailed. It's too late for Your Excellency to exercise supervision over the use of this court's orders in accordance with the established guidelines. That's an alarming proposition and is obviously wrong. There was a brief attempt to defend Trafigura's conduct in the onshore proceedings. He had 2 points about the arrest warrant in particular. The first was that it was also sought not only on the impossible basis about the payment into court, but that the arrest warrant was also sought on the basis that Mrs. Gupta had not yet disclosed the documents required by the Cook order, so Trafigura needed to obtain them as well. But Your Excellency, that is chronologically wrong. The document required by the interim order was the sale agreement. That reference for the interim order is D9/1272 at paragraph 6. Now, it is true that Mrs. Gupta did not produce that on time. She has since done so and apologized. But what happened in the meantime is that Trafigura had obtained that sale agreement from the Dubai Land Department. And the Dubai Land Department had produced that contract in response to Trafigura's application on the 20th of November, 2025. The reference for that is L5/2335. And Trafigura then applied for the arrest warrant on the 11th of February, 2026. That's at L132404. So this is a bad point. The arrest warrant was not sought because Trafigura wanted the sale contract. It was sought because Trafigura wanted to put Mrs. Gupta in prison for not complying with an obligation that they knew she could not. What better way to bring a judgment debtor to the table than putting his wife in prison? The second point that was taken about this was that, as it turns out, they did not actually get the arrest warrant. Well, it's true that the court required Mrs. Gupta to be given notice, and that at the return date on the 23rd of February in this court, Chief Justice Martin made an order restraining Trafigura from taking any further steps in that regard. As I'm sure Your Excellency can understand, that is of little comfort to Mrs. Gupta. Unless there's anything further I can assist with, those are my submissions in reply.
Thank you, Mr. Trotter. Well, the freezing orders have generated a very substantial body of jurisprudence in this jurisdiction, and I've been much assisted by the comprehensive and helpful submissions of counsel. Obviously, I'll reserve my judgment and deliver it as soon as I can. So thank you very much.
Thank you.